Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Blake. To my left, Justice Shin. We will be hearing 5 cases this morning. The rules of argument are as they always are here, for those of you who have been here before. 15 minutes per side. There's no rebuttal. And if, in any case, lawyers are going to divide the time on one or another side, you need to let us know at the outset what division of time you would like. With that, we will turn to our first case of the morning, which is number 23-154, Commonwealth v. Cepeda, and we will hear first from Attorney Murphy.
Good morning. Owen Murphy for Mr. Cepeda. The Confrontation Clause guarantees the defense a full and fair opportunity to probe the veracity of the evidence that's introduced against him. And he does that through cross-examination by exposing infirmities that call the fact finder's attention to the reasons for giving scant weight to the evidence against him. And whether there was an effective opportunity for cross-examination is analyzed on a case-by-case basis. So in this case, the Commonwealth acknowledged the fact that the only evidence indicating Mr. Cepeda had any idea that a firearm was going to be produced was a couple of lines within Mr. Bellow's grand jury testimony. And this is the Commonwealth's own characterization of that evidence. The way that reads is it almost suggests that those things are happening in sort of a chronological order. This was not reliable evidence that Mr. Cepeda shared the intent to use a firearm. This evidence called for cross-examination. And as to corroboration, corroboration has to be substantial and it has to be specific. In this case, on the whole, the record suggests that Mr. Cepeda was not privy to any idea that a firearm was going to be produced.
You said that corroboration has to be specific?
It has to be specific to each element. There needs to be corroborating evidence of each element.
What's your best case on that?
I think the best case is Noble, which I discuss in my brief, is helpful. I'd also direct the court's attention to Ragland, which, in retrospect, I wish I had put a little bit more fully in my brief. But in that case, I think it provides a valuable contrast because the grand jury testimony in that case indicated that Mr. Ragland was...
That's cited in your brief, Ragland?
I believe it's definitely cited in the Commonwealth's brief, and I cite it in my brief, albeit briefly. I do have the site.
No, I just wanted to make sure I had the citation.
I don't think you're going to have trouble finding it, but I have the site that I can look up if you want. But I think in that case, it's an important contrast of the type of corroboration that we need to look at to say that this was substantial corroboration and specific to the element that is in question. And in that case, there was a question of whether or not the defendant Ragland had used a knife to stab Paul Pierce. This was an incident from 2006 or so.
Right. So I have the case, but do you have a case where the court found inadequate corroboration? Because Ragland, there was enough corroboration, as there was in Noble, and I'm just wondering if you have a case that goes the other way.
I don't really have a case on that. I think they are out there.
Well, I wasn't able to find one, so yeah, so the cases are a little bit cryptic to me about exactly how much corroboration you need in this context.
Fair enough, Your Honor, but I would invite you to contrast Ragland, and the point being that look at the 4 different points of corroboration that the court relied on in that case. It was a detective's testimony about an interview that happened at the police station, the detective testifying on the record about the same victims, the recanting victim's statements, says that at that point the victim reported that Mr. Ragland was stabbing Paul Pierce. Also, at the identification procedure, that same victim identifies Mr. Ragland from a photo array and indicates that he's the person who's stabbing Paul Pierce. A third witness, or a second witness, who was at the event, notes that she saw Mr. Ragland washing blood off of his hands after the event, consistent with a stabbing. And there was yet another corroborating point, which was that Mr. Ragland was the leader of the whole skirmish and that he kind of led the charge and that he was involved piling on Mr. Pierce with other individuals who were charged as co-defendants. And so all of that is very specific to the fact that Mr. Ragland was the perpetrator using the knife, which the recanting witness denied at the trial. In this case, all we have is evidence that Mr. Cepeda's at the door. In this case, the grand jury testimony itself doesn't even indicate that he has any idea that a gun's going to be produced. And Mr. Paulino's grand jury testimony further undermines that because he says Cepeda's at the door and that Mr. Bello's focused on whoever's in front of him, Mr. Encarnacion, and at that point, Mr. Bello becomes shocked while Mr. Cepeda's at the door focusing on the door. So from all that appears, this was just a rogue reaction that Mr. Cepeda had no idea was going to happen. There's nothing to corroborate that he had any intent to produce a firearm or to use it in the shooting. I mean, the evidence corroborates the fact that he's at the scene and at the door, perhaps, but other than that, there's just no way you can say that he had any intent to use a firearm.
What's he doing at the door?
He was attempting to remove Mr. Bello or open
Why?
the door. Certainly there was some type of, I don't think there was any evidence as to why, other than, again, an uncorroborated suggestion that Mr. Encarnacion directed him at the door.
Okay, but that doesn't, okay, why?
He was
But
trying
if
to
he
remove
had
him from
told
the
him to
car.
stand in front of a moving car and be killed, he wouldn't do that. So what intent do you think he had in opening the door? What was the purpose of that?
I think you could fairly infer that there was an intent to assault Bello, and
Mm-hmm.
really nothing more than that. And merely acting.
Well, assault and batter, presumably.
Presumably, perhaps.
I mean, why else are you dragging this guy out of his car? He's in the driver's seat of a car.
I mean, he could have just opened the door and yelled at him, too. I mean, why would
Yeah,
he
he
drag
could
him out?
have, but he's surrounded by 4 other guys.
Why would he drag him out of the car if he thought that somebody was going to shoot him? What's the point of that? Why would he drag him out of the, why would he put himself right next to him if he thinks somebody's about to shoot him? And again, I think Baxter and the cases cited within Baxter are important for the proposition that, merely making actions which demonstrate an intent to commit an assault are insufficient to show that there's a shared intent to commit a shooting. And all we have here is very vague evidence that he may have had the intent to commit an assault. I think it's also important to note how this came in before the jury. An officer reading it, the exhibit itself, I don't believe was ever published to the jury. So I think it was undoubtedly confusing, and I would also...
It was what? I'm sorry, I didn't hear you. What did
that?
you just, I didn't hear what you just said.
I think the presentation of it was certainly undoubtedly confusing, and the prosecutor marshaled it and took artistic license during her closing argument, saying,
But you said it wasn't what to the jury? Someone coughed, I couldn't hear you.
sorry, yeah, the way it came in before the jury was Officer Ulrich basically just reading the
Read it.
transcript. And then during the prosecutor's closing argument,
Yeah, but what did you say? It wasn't something to the jury?
I think it was undoubtedly confusing to the jury, the way that it came in.
But you're not saying that's a prohibited way of bringing in grand jury testimony?
No, I'm not.
Okay.
But I would just say that in this case, it was very kind of a fleeting remark from Mr. Bello's testimony, which the prosecutor then took artistic license with, saying in her closing argument, he's already at the door, and Mr. Encarnacion's pointing the gun. He had already taken it out, and Mr. Cepeda saw it. He's already at the door, and he's still trying to pull him out. And there's just nothing in the evidence that says that. And I think,
Well, there was no objection to the closing, right?
no,
I mean, so it can be inferred from the testimony that that's what happened.
I don't think so, no.
You don't think
I
so?
To infer that from the grand jury testimony is basically Mr. Bello saying, Mr. Encarnacion did X and Mr. Cepeda did Y, but there was never any opportunity to flesh out exactly the specifics of it or how X related to Y or when those happened in relation. It was just very vague and unclear and raised more questions than it had, and it certainly wasn't reliable proof that Mr. Encarnacion had already taken out the gun and was pointing at it at Mr. Bello. And in fact, Mr. Paulino's testimony contradicts that point too, because he says that as soon as the gun was taken out, and I know I said this already, but as soon as the gun was taken out, that's the moment that the shock set in, and that's the moment that Mr. Bello accelerated away, and Mr. Cepeda was already at the door at that point. So we have two pieces of grand jury testimony which tend to contradict themselves, in which the defendants didn't have any fair opportunity to cross-examine.
On the question of the shared intent, what, if anything, can we infer from the acquittal on the armed assault with intent to murder?
Yeah, I think that the jury must have found that there wasn't actually any intent on Mr. Cepeda's part to effectuate a killing, but they certainly...
We can't draw anything from that intent.
I don't think he had the requisite malice for that charge, but I think they did.
A second question is, I know there were other defendants in this case. On the record that we have, do we know if anyone else has successfully raised or has pending the grand jury issue?
Mr. Rojas's case was decided, and I had an opportunity to speak with his defense counsel, and I was thinking at that point that perhaps he was successful in keeping out the grand jury testimony, but that's not what happened. He basically wanted it in and made some type of argument that Mr. Rojas only had the intent to shoot in the air because there were some statements to that effect that were communicated at the trial and within the grand jury testimony from Bello and Paulino.
You're saying that the appeals court has issued a decision in that case?
No.
He was acquitted, right?
He was acquitted.
Oh, I see, okay.
And then the defendant who was tried with, the co-defendant who was tried in this case, he has not appealed, is that correct?
It's my understanding. I'm not knowledgeable about him filing any appeal.
That's Encarnacion?
Yes.
Okay.
Do we have to reach the grand jury issue if we agree with you on sufficiency?
No, but I think in either case, the outcome would be that there was insufficient evidence, either with or without the grand jury testimony. I think there was insufficient evidence even with the grand jury testimony based on the fact that it didn't demonstrate that Mr. Cepeda knew that Mr. Encarnacion was going to brandish a firearm. So that might be an easier way to reach the same resolution. But I think even with it, or without it, certainly the evidence was insufficient. So.
And if we agreed with you the evidence was insufficient of intent, shared intent, knowledge of a firearm and shared intent that it be used, the remedy is this has to be knocked down to a lesser included offense of what? Assault and battery?
So I think that he was convicted of the assault and battery of Alcantara. I think if you find that there's no shared intent to use a firearm, that conviction's vacated completely, because then all we're left with is him approaching the door, specifically targeting Mr. Bello. So I think that could be reduced to an assault of Mr. Bello.
So the ADW gets reduced to assault and the ABDW is vacated?
Correct. I know there's an issue of transferred intent, but that doesn't apply if he's not sharing the intent to fire into the car. And certainly I would suggest, and I say this in my brief, an intent to place Ms. Alcantara in harm doesn't exist when the action that he's taking is to pull Mr. Bello out of the car away from her. There's no harm being proffered to her at that point.
Were the jury instructed on lesser included offenses?
I'm sorry, can you say that again?
Was the jury instructed, I don't know why we call the jury plural here. Was the jury instructed on the lesser included offenses? If you find that he did not share the intent, you may find him guilty of.
I'd have to read it again to answer whether or not they were so specifically instructed that they could return a lesser included offense, but I think effectively they were, given that they were given charges or instructions on each of the elements.
I'm just trying to think about joint venture. It's sort of a weird Zanetti question or something I'm trying to figure out.
Put at me.
Because to be a joint venture for regular assault and battery, there's nothing about intent to use a firearm. It would be like with the shared and standing by, ready and willing to able, ready and willing to help with shared intent. But that's not an element that was found. The only elements that we know were found are the elements of assault and battery, even if they were instructed on the lesser included offenses, since that's not what they found. Although,
Right.
is that a lesser included offense? Because it's got a slightly different intent requirement. We can figure this out. This is,
Yeah,
It doesn't
it
appear
could
that they
be,
were instructed on the lesser includeds.
it could be the case that their verdict for the charges involving Bello were based strictly on Mr. Cepeda's shared intent to fire into the car, and that they didn't credit the evidence that he approached the door, which in some ways would make sense because Mr. Rojas's testimony puts Mr. Cepeda at like a totally different position of the car, standing next to, or that's Mr. Paulino's testimony, puts him in a different spot, standing next to Mr. Rojas. So there could be a question whether or not they unanimously decided whether to credit the evidence that he even approached the car. It could be that everything was just based on his shared intent to fire into the car with Mr. Encarnacion, which
we
don't have
will
any
ask
evidence.
your colleague about this as well. Your time has expired, so unless there are further questions, thank you very much.
I
Very
just,
good
in
argument.
closing, I think,
And no, you're out of time. I'm sorry. Thank you.
hi, Auntie.
Morning, may it please the court, Kristen Jing for the Commonwealth. And I'm happy to start on the issue of cross-examination. I think the case law is pretty clear, in particular Andrade and DePina, which I cite in my brief, that any limitation on the effectiveness of cross-examination where the witness is found to have been feigning memory loss does not implicate the confrontation clause. In addition, in this case in particular, defense counsel had the opportunity to cross-examine both witnesses, and as to one of them actually did. So I don't think that the case law supports the contention that.
But what does cross-examination really mean when a witness says, I don't remember?
I agree, but we have this whole area of law that goes to feigning of memory loss, that says that we can introduce grand jury testimony for its truth in these particular circumstances.
And somehow it's different than, we know real memory loss, of course, can, if it's sort of complete, can in fact limit effective cross-examination, though I completely agree with you. Andrade seems to, and I'm not sure why neither of you sort of just emphasized that case. It does seem to say, and it has the word generally in it, but it does seem to say feigned memory loss is different, and even there's a case after that from the SJC that has a footnote saying, like, this doesn't seem like a feigned memory loss case, see Andrade. So, why is it different? Because now you've got a lying witness, which of course you could have, and I mean, that's the point of cross-examination in part,
Yes.
is to figure out, is this a lying witness?
Yes.
Although in this case, it's really the Commonwealth that wants to show that this is a lying witness, and indeed, what might ordinarily be called cross-examination was undertaken not by the defendant, but by the prosecutor, asking again and again, and you don't remember saying this, and you don't remember saying that, and you don't, to create the obvious impression. I mean, it was quite obvious, I think. This guy is lying. Somehow he remembers, his conversation with somebody, in between. No, I remember going to the, to the place or whatever. So it seems like the message would have gotten to the jury, this is a person who's lying right now. Presumably, the defendant would want, I'm not sure what they would want in cross-examination, maybe to press more on, you can't even say that you signed this. You can't even say, you don't know where it came from, right? And
Yes.
you know what I mean? So, I mean, I guess that in that sense, the person, if they're lying or might be lying, but it looks exactly the same to the jury as a person with real memory loss. I'm just not sure why there's a different rule for feigned and for real.
There is a case, and I don't remember the name of it, but it's absolutely cited in my brief. I just remember when I was preparing for this, trying to understand this exact distinction. And there was a case that talked about honestly, the best quote-unquote cross-examination from the defense perspective, if they don't want this in, is the fact that the witness is lying, right? Are you lying now or were you lying then? So you don't really need actual cross-examination in the classical sense. From the defense perspective, they just want to completely eviscerate the credibility of this witness, right? Because they don't want the jury to believe that prior recorded statement. So just the fact that the witness is there saying, I don't know, I don't remember, and the fact that they told a totally different story, a year before, I think that is the difference versus someone who, I don't know, had some sort of traumatic brain injury or something, and that's why they can't remember. That's just a very different type of witness, where here it appears that the witness is lying, that they can't remember. As to the issue of corroboration, there are cases that say corroborative evidence need not be sufficient in itself to establish a factual basis for every element. There are cases that said there's no requirement that the evidence be of a different nature than the grand jury
But
testimony.
the cases say it has to be corroboration of the element, right?
Yes.
So what additional evidence is there here of the element of intent?
Of intent. So we do have I agree that the strongest evidence is the grand jury testimony. There's no question about that.
Isn't it the only evidence?
I believe that some of the other evidence shows the joint venture and the intent here, in that there's surveillance video footage, that shows the defendant running towards the scene just before the shooting happened, fleeing with the rest of the co-venturers.
Right, but I still don't see how that's evidence of his intent or knowledge that any of his co-venturers were armed with a gun. And wasn't it the case that everyone else was already there and he was at his car and he runs at the last minute while this is all already happening?
We don't know exactly when it started happening.
They
but
went
he did
first,
run
right?
to
And
the
he
scene.
runs later to the
Yes,
car.
exactly. I think also very strong evidence is the photo array IDs where both Paulino and Bello said.
And again, yeah, it's strong evidence he was the man who was trying to open the door. I just don't see how that's evidence that he knew or intended to use the firearm.
Well, he intended that a firearm be used in this assault with the rest of his co-venturers. We don't need to show that he had a gun, but he continued to try to open that door after firearms were pulled out. I think that's what's important here. So the evidence of the photo array of Paulino and Bello saying, yep, that was the guy that was trying to get into the car, and evidence showing him running towards the scene and fleeing with the rest of the co-venturers is corroborative evidence.
Okay, so where are you getting that timeline? The timeline that he tried to open the door after the guns were pulled out?
It is inferred from the testimony. Both
The
Bello,
grand jury testimony.
The grand jury testimony, that's correct. So both Bello and Paulino in their grand jury testimony made it sound like this was happening simultaneously.
I mean, I read that part of the transcript multiple times, and first of all, it's conflicting, right? Bello said the shooter was at the front of the car, showed the weapon, pointed at him, and then before, after, during, I don't know, that while this was happening, the defendant's trying to open the door. Didn't he say also that the defendant himself had a weapon?
That the defendant also
The
had a
defendant
weapon?
himself had a weapon. He was talking about the man with the
Yes,
piercing had a
yes.
weapon, right? So he says the defendant has a weapon. Then Paulino says the shooter's at the back of the car. The victim says the shooter was beside her on the passenger side of the car. I mean, it's really hard to tell here what's going on.
Well, at the same time, this is also someone who had guns pointed at him, and he had to drive away from the scene,
Yeah,
and he
no,
almost
I
got killed.
understand.
So, we're never going to be dealing with perfect testimony in these
Right.
situations. So, but at the same time, it's pretty undisputed that this defendant was trying to get into the car, and it's undisputed, I think, that at least Kimiko had a weapon out, obviously. Shots were fired. So I don't think it's that far of a leap to show that this defendant saw guns out as he was trying to get into the car.
Well, but it's a leap
I think it's an inference, and I think it's a fair inference.
beyond a reasonable doubt.
Yes, I think it's a fair inference.
Without
Viewing the evidence-
cross-examination on this topic, that's the issue.
I'm sorry?
Without the opportunity for cross-examination on this issue, right?
At the same time, the testimony was available to speak on during closing argument. All these inconsistencies could have been pointed out during closing, and I don't see an ineffective assistance
When you
claim
have
here.
the testimony, the grand jury testimony of two witnesses that conflict in some respects, how does the jury choose which one to believe from just a reading of their testimony?
I don't think the jury needs to decide where all these players were exactly where they were standing to decide these issues here. I think they need to make that inference, and I think it's a fair inference from the grand jury testimony that this defendant took an affirmative step once those guns were out. And I do think it's a fair inference from the testimony, the grand jury testimony.
If we concluded that the evidence was insufficient on intent, what's the remedy?
And to be frank with this court, I didn't do any research on this, but my instinct is that it would, the conviction would have to be overturned. That's my instinct, but again, I didn't.
Both of them?
Yes. Yes. But again, I didn't do any research on
Would be that there's nothing left.
Yes. If there's no intent, I'm not sure where you go from there. If the evidence, if there was insufficient.
But the intent they were asked about was the intent to, knowledge of a weapon and intent that it be used in the commission of the crime.
Yes.
And there is no lesser included offense of that.
Again, I didn't do any research, but my instinct is no.
Assault and battery is not a lesser included offense of assault and battery.
I suppose it is.
Although I agree with you that in assault and battery, if there'd be a different intent instruction that they didn't get, right?
Right. Because the evidence was really based on the guns here being out, right? So, yeah, this is true. I apologize. I wish I had thought about this before, and I could have been more helpful to the court.
That's okay.
If there are no further questions, I'm happy to rest on my brief. Thank you very much.
Thank you very much. Very good argument. The case is submitted. The next matter we will hear is number 23-198. It is Commonwealth versus Amato. Okay. We will hear first from Attorney Tomposki.
Good morning, members of the court. Michael Tomposki for Joseph Amato. Your Honors, the defendant's convictions should be reversed for several reasons. I'm going to start with both the judge's error and defense counsel's error in abandoning a claim of self-defense after both had promised the jury throughout jury selection, and defense counsel having promised in his opening that a claim of self-defense would be developed, where the factual record supported an instruction for self-defense, use of non-deadly force in self-defense. And that was the defense that best gave Mr. Amato the chance of an acquittal on the assaultive offenses. Taking the evidence in a light...
I take it you were not the trial lawyer.
Was not.
The trial lawyer's strategy, or I don't want to use the word strategy here, the defense that the trial lawyer seemed to rely on more was accident, right? And that's partly because the victim's testimony, I assume, it's partly because the victim's testimony involved an accident. Now, that's not to say self-defense wasn't presented on the evidence. I think that's a very tricky question. But let me ask you this. Don't we need to know if it was a strategic decision by the lawyer to not pursue self-defense, maybe in light of the victim's testimony?
I don't think so. And here's why. I think the evidence that Mr. Peters, who is present in court today supporting Mr. Amato. The evidence that he testified to appears to have been what counsel anticipated, because counsel indicated in his opening that this would essentially be the testimony, and based on this, you should expect us to raise a claim of self-defense. There was not a significant deviation from what counsel expected Mr. Peters' testimony to be based on his opening to what Mr. Peters eventually testified to. Now, to your other question about whether it's more accident or it's more self-defense, I think it was very clearly both, and both were abandoned, or at least not requested. One was abandoned and one just simply wasn't requested at all. I think that the best defense for Mr. Amato was that the initial encounter, where they were struggling in a non-deadly way, that Mr. Amato acted in self-defense, and that the injuries sustained by Mr. Peters, the serious injuries, were inflicted by accident. And those two defenses are not mutually exclusive. And Best gave Mr. Amato a chance of acquittal.
I'm going to use the word that Judge Rubin didn't want to use, which is strategic. This goes right into your next argument about ineffective. This is absolutely, in my view, something you cannot ascertain from this cold record. I don't understand why there wasn't a motion for new trial here. I don't know how you ask us to decide it on a cold record like this.
I don't think the record is that cold, I guess is my response. I mean, certainly, I would say two things to that. Number one, the record isn't cold. I think you have very clearly, defense counsel lays out the strategy, both through the jury voir dire process and in the opening, and then abandons it for reasons that are illogical and not based on the law, number one.
You say they're illogical, right? I've read the whole transcript multiple times. I could make an argument why there was a strategic decision, but I'm not going to do that. I want to know from trial counsel why he did it.
I understand that is generally...
Anything that precludes you from returning to the Superior Court and having a hearing on a motion for new trial after we decide this case?
There isn't. I would say one other point, which is that the judge also ruled, this is sort of a dual claim, the judge also ruled that self-defense was not warranted based on the evidence. So in the event that the court does not want to make a ruling on ineffective assistance, the court could alternatively rule that this raised a substantial risk of a miscarriage of justice and unobjected to error in the instructions.
So the Commonwealth says, actually I'm not sure how to articulate what the Commonwealth says, that, I'll try to make it more concrete than it is in the arguments, that if it was self-defense, it was a stabbing with a part of a bottle. And that there wasn't sufficient evidence to warrant an instruction that that amount of force, deadly force, was acceptable. Or I think that's their argument. Can you address that, or whatever you think their argument is?
Sure. I will try to address what I think their argument is, which is that because Mr. Amato was charged with aggravated assault and battery and was charged with assault and battery to change his weapon, that he was only entitled to self-defense instruction if he was threatened with deadly force. But that isn't how you determine whether someone is entitled to a self-defense instruction. It's determined based on the facts that develop at the trial. And the facts that developed at the trial in the light most favorable to Mr. Amato, taking all the testimony that he would proffer in support of this as true, is that he was the victim of a non-deadly assault and responded in kind. And again, getting back to the accident issue, that the injuries were the result of an accident. The serious injuries to Mr. Peters were the result of an accident. So the Commonwealth is wrong about the standard. The standard, based on the evidence, based on Mr. Peters' testimony and the corroboration, is for non-deadly force and self-defense. That's the instruction that was warranted. Also pointing out that Mr. Amato was also charged with misdemeanor assault and battery.
But let me ask you about this, because at transcript 4, I think it's pages 26 to 29, where the victim is testifying on behalf of your client, he says, quote, this is the victim, he wasn't trying to hurt the defendant and grabbing him, even though, while the defendant had the bottle in his hand, which broke. So if the victim is saying, I wasn't trying to hurt the defendant, I read the Commonwealth's brief as suggesting that that does not support an inference for the use of deadly force, because the victim, his own testimony was, I wasn't trying to hurt him. So why do you have to respond with force?
That is their argument, and we never suggested that Mr. Amato was entitled to a self-defense against deadly force instruction, that he was entitled to a self-defense against non-deadly force instruction based on the evidence as it developed at trial, that counsel promised would be developed, that the judge initially agreed was warranted, and then both the judge and defense counsel decided, based on, I don't know why, no one really said, that it wasn't appropriate anymore, counsel acquiescing to the judge's ruling, essentially.
And is it your view that what the judge instructed as to accident, and this is at, again, transcript 4, I think in the 90s, the Commonwealth must prove that the touching was not merely accidental or negligent. That's insufficient in your view?
It is legally correct but insufficient, because the model instruction on accident is far more detailed and really focuses the jury on the decision that they have to make. And I include the model instruction at page 7 of my reply brief, and I know the court, of course, is familiar with it. Simply saying it has to be intentional, while true, if that were enough, we would never
And not an accident. I mean, it has the word accident in
Or
it.
negligent?
And if that were enough, we wouldn't need a model instruction on accident. We have that.
Well, I
for a
don't know
reason.
whether we need model instructions or not. The question is.
Someone thinks we do.
That seems clear. And some of them are good.
And I think this one is good.
But the question is whether an accurate instruction, you're asking us to say that's not adequate. It is accurate, and it covers it.
It's accurate.
But it's not adequate.
Correct.
And so everyone in every case where accident is a defense will have to say more than just and prove beyond a reasonable doubt that it was not an accident.
I'm not suggesting that the court needs to make a ruling about what every case should be. I wouldn't suggest that.
Oh, but that's how our rulings work. They apply to other cases.
Well, they apply based on the facts of
Yeah.
the particular cases, and obviously they may apply in other cases, they may not.
Yeah.
I think the issue here is the combination, quite frankly, of the instructional errors and counsel's failure to make the proper request, the judge's failure to give the correct instructions, all either raise a substantial risk of a miscarriage of justice or amount to ineffective assistance.
So could we
of
stay for a
counsel.
minute on the accident self-defense issue? Similar to what I asked in the prior case, what, if anything, can we glean from the acquittal on the assault with intent to murder charge?
I think I don't think we can glean anything as it relates to the claims that I've raised. The jury just didn't believe that there was an intent to murder. I don't think it affects the arguments that I'm making as to the instructional error in any particular way.
Can I ask you about the sufficiency on the intimidation of a witness on the trial?
Yes.
I'm struggling because you're suggesting that the jury was entitled to an instruction on the criminal harassment statute. I'm having trouble understanding that because I don't read the case law and the statute for intimidation of witness that the Commonwealth has to prove criminal harassment. So can you help me with that?
Well, I believe that's in the definitional section of the intimidation statute.
Harassment is.
Yes.
Okay. There are varying forms of harassment from the 250-80 orders
Yes.
through the intimidation statute, through the crime of harassment. Are you saying that the intimidation of a witness statute requires an instruction on the crime of harassment?
No, I'm not the crime of harassment.
Okay,
I'm saying that putting aside the sufficiency issue, just on the instructional issue, I'm saying that the jury wanted to know what harassment meant, counsel wanted the jury to know what harassment meant, and 13B includes a definition of the word harass, and that is what counsel asked the judge to instruct, and the judge said, no, they can just figure out, essentially, what it means based on, I guess, their common sense, but we don't know what that means, what their common sense is. We include the dictionary definition of the word in our brief, and it's not the same as the definition in 13B. And so our position is that was error, and that's preserved error, one of, I'll acknowledge, the few preserved errors that we're raising here. On the sufficiency, I think it's a completely independent argument, and the Commonwealth never really deals with this. There's actually two counts of intimidation. One is the date of offense, and the other is diverse dates. The diverse dates one appears to be the jail calls, and I don't need to necessarily detail that. It's detailed in my brief, the evidence as to why we don't think that is sufficient. But the Commonwealth makes no argument, and never made it below or here, as far as I can tell, that what the intimidation was on the date of the alleged assault. It's two separate counts. And so
I didn't read you to be making that argument either.
well, we raised a general sufficiency challenge, and I'd be perfectly frank in my preparation for coming here today, and I'm happy to address this with supplemental filings if I need to. I realized that one of the counts was specific to the date of the alleged assault, and that the Commonwealth has never suggested that what the evidence was that supported that particular count.
I don't know that you can raise that in a supplemental briefing.
Well, I'm pointing it out for the court. We raised a sufficiency challenge, and I think the Commonwealth is obligated to meet
Do I read
it.
your sufficiency challenge to basically be saying that the victim had to feel harassed or intimidated?
Not had to. I don't think it's subjective.
Because if someone says to someone, you know, we shouldn't be talking, you should try to erase the phone, please don't say what you said on the 911 tape. I'm paraphrasing completely. But things of that nature, and I put that in the context of a domestic violence case, which this is. Seems to me that this is maybe not so subtle, but a subtle way of saying, you got to get me out of here, you got to change your story. That's intimidation of a witness.
Well, you know, I understand the arguments. I think the statute requires more than suggestion. It has specific language: intimidation, harassment, misleading, and those words have meaning. And our argument is that whatever the conduct was, you know, that didn't really happen. Why are you saying that? Words to that effect don't amount to intimidation. The other conduct you're talking about, delete the phone, was the basis of a separate charge, which we have not raised.
The withholding evidence.
The withholding of evidence.
Can I ask one more question about, and we can go a little over if we need to, but a question about this instruction on harassment. You requested it not at the charging conference. You requested it, not you, but whatever, you're the defendant.
Understand.
Requested it in response to a question that didn't ask about it. So, why would the judge give that instruction in response to a question that didn't ask about it? I'm looking at what I gather is the question. Re-indictments 4 and 5, in the first part, is it all bullets or simply one? I can't really read what it says, any or all. Re-indictment 1 and 2, can you define intended? The defendant intended to touch Mr. Peters. And so,
I believe it was in the proposed instructions, the written instructions, Your Honor.
where are
And if they're not, and
the
if they're,
Commonwealth says that this was proposed only in response to a question. They may be.
I don't think that's correct. I believe that in the written instructions counsel submitted, and that's what's in, I mean, I don't have the written instructions in front of me, but that's what's in our brief, that he requested in writing. The judge refused to give it. Then the question came back. He renewed it, and the judge refused to give it.
We'll ask your colleague. More? Your time has expired. Thank you very much. Excellent argument.
Thank you.
And we will hear next from Attorney El-Khoury.
Good morning. May it please the court. Rosellen El-Khoury for the Commonwealth. So just to address what was last being touched on, Your Honor is correct, page 203 of the record transcript. The question that was received from the jury was with regards to charges 4 and 5. Is it all the bullet points or is it just one? And the judge's response to that question was responsive. It was, you may consider any or all. It was basically an explanation of that phrasing.
In fairness, though, I just found at record 26 in trial counsel's proposed instructions, he requested a proposed supplemental instruction for harass and a proposed supplemental instruction for intimidate.
Yes, in my reading of the brief, it was my understanding that the challenge raised was specifically to the response to the jury question. To the extent that it wasn't, however, I don't think it was an abuse of the discretion for the judge not to give that instruction.
How can that be?
Well, it's to add to that where there is not one specific course of conduct that was charged as.
But it's part of the statute.
It is part of the statute, but, not all jury instructions give every part of the statute in
Well,
the
to tell them
instruction.
they have to find harassment, and it's got a very specific definition, and not tell them what amounts to harassment, when you've been asked to do so, seems,
To the extent that it may have been, it may have been an error. I don't think it was reversible error, and I don't think it was an abuse of her discretion not to give that where there was no specification that is only harassment, if I recall correctly.
So the discussion of this at trial, in response to the jury question, the judge refers to the model instruction, which she said is what she gave. And then the definition of harassment is in a supplemental instruction?
Yeah, a supplemental model.
And she says, without really explaining why, but I mean, this was in response to the jury question, which didn't ask this, but she says she didn't find the supplemental instruction warranted on the facts of this case. Do you have any insight as to what that
I do not have
means?
any insight into what the judge meant at that time. I was not the trial attorney. I couldn't, and I wouldn't presume to speak for her.
But do you know, so when, does the supplemental instruction, does it say when it should be given?
I don't recall off the top of my head if there is any guidance on when it should be given. I don't believe so, but I wouldn't want to be wed to that answer. I apologize, Your Honor. If there are no further questions, I'm happy to rest on my filings.
No, I have some questions, sorry. I was just still thinking that through.
Oh, no.
Is the portion of the instruction that the judge gave, I've got to find it again, on accident sufficient? I mean, this seems to me, if thinking about the facts, that perhaps the glass breaks in some way, and somehow the victim ends up in contact with it, potentially accidentally, right? Is he entitled to a separate accident instruction, or do you think that, I mean, I know what your brief says, is that enough? And so to counsel's point, why do we have a separate accident instruction if what you say in your brief suffices?
Well, I do think that had it been raised, I don't think the Commonwealth would have objected to giving an accident instruction. I think that the evidence could be viewed to support that, especially when taken in the light most favorable to the defendant. That being said, it wasn't requested, and the issue here is ineffectiveness.
So let's talk about that. I obviously asked Mr. Amato's counsel about why there wasn't a motion for new trial. You've done enough of these, you've seen enough motions for new trial. What would the argument be that there was a strategic decision, notwithstanding what was promised or said in openings about self-defense and accident? What would be a reasonable strategic decision to not pursue that?
I think based on the evidence, the testimony of the victim that he gave on the defendant's behalf was that he injured himself when he fell. He, said that he grabbed the defendant. There was no testimony about the defendant sort of making any kind of reciprocal aggressive touching in any way that would have led to injury. So I think
So arguably something different than perhaps that they thought the testimony might look like initially?
Potentially. That being said, I would also just like to draw the court's attention to the fact that the judge actually did not rule on the self-defense instruction. I believe it is page 81 to 82 of volume 4 of the transcript, in which she says, based on what I heard, I don't think that a self-defense instruction is warranted, but we're going to go to the break, and then when we come back, we'll have a further discussion on this. And when they returned, it was trial counsel who said, reading it thinking about it, I don't think self-defense, I'm not going to ask for it at this time based on the facts as they are. So, again, the Commonwealth does believe that this would be better raised in a motion for new trial, but to the extent that the court feels that this is obvious on the record, this was a strategic decision, it was not an unreasonable decision, and did not fall manifestly below the work of an ordinary trial lawyer.
On the jail calls, counsel raised, we didn't really talk a lot about this during his time, but raised a number of reasons why he says they're inadmissible, and you respond to those. But what is your strongest argument for why they're admissible? What's your lead-off point?
Absolutely that this was strategic. Even if you go back to volume 1 of the transcript, I believe it's pages 8 to 9.
But otherwise, would you say they were inadmissible?
I think that it is difficult to play a conversation between two individuals that takes place outside of, a courtroom and sworn testimony in its entirety without agreement and say that none of that is going to fall within a hearsay category. I wouldn't stand up here and try to make that argument.
So you could put in Mr. Amato's comments as a statement of a party opponent, I guess, but you couldn't put in the victim's statements to put them in context.
You could put some in to put them in context, but some of these conversations were, 5 to 10 minutes, and without having the benefit of having an argument on this and partitioning the different portions that the Commonwealth would want to submit, I am not going to stand here and say that there's no element to any of these that would have been, or that would not have been.
Were excerpts of that length played to the jury?
I'm sorry?
Were excerpts 5 or to 10 minutes long played to the jury?
I believe both sides played different conversations in their entirety, and I know that the transcripts obviously have them for a couple pages. The recordings also, if you listen to them, I'm ballparking. I want to say, I know there's at least one that is around 6 minutes. So to that end, to claim that nothing that was said during that would not be able to be excluded on the grounds of it being hearsay, I think would be an overreach.
Although it's not all going to be prejudicial.
Sorry?
It's not all going to be prejudicial if they're talking about whether the cat was fed or whatever.
No.
I agree, maybe that's not supposed to come in, but it's not about anything.
No, and the fact that there were no objections here, given the fact that trial counsel did review what he knew the Commonwealth intended to submit, speaks to this being strategic. It was not inappropriate for, once these calls were admitted, for the Commonwealth to use them in every way that it was possible to use them, to support sort of every charge that it was possible to support with them, because they were properly admitted and there were no objections.
Staying on this topic, why were the terms verbally abusive and abusive excludable?
I think it's the term abusive itself. I think all the parties seemed during...
They agreed there wouldn't be specific acts, right? But abusive is a way of describing a series of events. So is that off limits too?
It's not being a judge myself and not being the judge who presided at this trial, I can't really make the call, but given that it is a term that can be viewed as inflammatory, I understand the instinct to sort of err on the side of caution when that term is being used, and I don't think it was inappropriate to do so. That being said, there were instances where the victim did refer to himself as verbally abusive that were not objected to and that were properly before the jury for consideration.
Staying on this topic, you say this should have been raised in a motion for new trial, but the way it's been briefed to us as an SRMJ question, don't we have to address each of the alleged errors in the admission of the statements? As opposed to just saying, sorry, you should have brought this as a motion for new trial.
I'm sorry, Your Honor, are we still talking in the context of the...
Of the jail calls, the
Okay.
statements that came in on through, taking them as a whole. I understand there's pieces and parts that have
Yes.
separate arguments, but generally speaking, you're saying no substantial risk, but this should have been raised in a motion for new trial.
Motion for new trial, or it should have been raised before, I'm sorry to interrupt, before the trial judge, so that she had an opportunity to rule. If there was going to be a challenge to evidence that the Commonwealth wanted to rely on at trial, that was the time to raise it. And the fact that it was not raised at that time and now it is being raised and challenged, the Commonwealth has not had an opportunity to parse and argue, okay, maybe this part wasn't admissible, but can we get this part in on these grounds?
But there's a substantial risk of a miscarriage of justice standard of review that we have to apply. I mean, if there were a true waiver rule like you're describing, then okay. But we have to review this stuff for a substantial risk of a miscarriage of justice.
Yes. I would argue that there is no substantial risk of a
Well,
miscarriage of
how
justice.
can you say that? You haven't told us what exact pieces of hearsay shouldn't have come in?
I don't think it's on me to tell the court what pieces of hearsay were inappropriately admitted. It was not
No,
my...
but it might be on you to tell us which pieces were appropriately admitted and why it's not prejudicial.
As defense counsel said, if the court would like me to submit supplemental briefings,
No,
I'm
that's...
happy to do so.
It's not a supplemental question.
But
I mean, you explain it's not custodial, you explain why that certain things didn't infringe upon his rights against self-incrimination.
Right.
But then when you get into the real specific, my word, not a legal word, picky-uni pieces of what should and shouldn't have come in as counsel has addressed them, outside of the fact that it wasn't custodial and did not violate his self-incrimination rights, I didn't see your brief as specifically addressing those other objections.
I think that the conversations could have been admitted to prove different charges, different elements.
I mean, you definitely say that about the intimidation of a witness piece, right?
Right. And
Say that globally. You didn't necessarily
didn't parse it down.
parse
And
it.
perhaps I should have filed for extra length so that I could have gone into more detail. But to the extent that there were elements here that were hearsay, and the court finds that it created a substantial risk of a miscarriage of justice, I would say that the Commonwealth disagrees with that view. This was evidence that was agreed to come in. This was, the fact that there may have been elements that the defendant now finds objectionable has really, I don't want to say disingenuous to ask the Commonwealth to address this at this point, but the appropriate time to address this was as they were coming in, raising objections.
No, I definitely understand that. There's so many of them, I'm trying to just get a better sense. In terms of the defendant's tone of voice, the evidence that was excluded there, that's really a best evidence rule. So to Judge Rubin's question, do we have a good sense in the transcript about how many, I mean, I know there were hours and hours of recorded conversation, how much the jury heard?
I think in total, the Commonwealth submitted somewhere around 40 minutes. I believe it was less than an hour in total what the Commonwealth submitted, and I believe the defense, I want to say somewhere in the realm of 20 minutes, but I am not sure and don't want to.
And is that a sufficient sampling on this question of tone of voice?
I would say that, if you listen to someone talk for roughly an hour, it's enough time to get a sense of their tone, especially, and you listen to these calls and you can hear there are different tones that are adopted at different points. You do get a feel for the tone of
And
conversants.
these are not comprehensive recordings of what was submitted? These are samples in both cases?
I think there may have been one exhibit that was not submitted, but by and large, I believe everything is before the court.
Okay.
I know the time is up. May I ask
No,
one
no,
more
please.
question? I know you didn't file a SIR reply brief. I'm not criticizing you for that. But in Mr. Amato's reply brief, he suggests, I think for the first time,
Yes.
that Mr. Amato is entitled to a new sentencing hearing. So could you briefly address that?
Sure. Obviously, as Your Honor has pointed out, this is a new argument that the defendant has raised in his reply briefing. There is no transcript of the sentencing proceeding before this court, so there's a limited record to go off
Have a
of.
sense of whether this was an integrated sentencing package?
There is nothing really beyond the claims raised in the reply brief that the difference in sentencing between the two intimidation charges is the reason that we can view this as a scheme. And I would say that setting
So if
aside.
hypothetically we reversed one of the two intimidation charges, how does that affect the sentence?
I think these are all sentences that were ordered to run concurrently, and I think they're all different sentences. I definitely don't.
He has a from and after probation, right?
He does have a from and after probation. I don't think it warrants, resentencing on all of the counts.
Thank you.
And if there are no further questions,
I see no further questions. Thank you very much. Excellent argument. The case is submitted.
I dropped something. I'll be right back. Dropping things.
The next matter that we will be hearing is number 23-855. This is Commonwealth versus Camacho, and we will hear first from Attorney Power.
Morning, Your Honors. May it please the Court, Andrew Power for Mr. Camacho. I'll begin with the first issue, ineffective assistance of counsel for failure to file a viable motion to dismiss. Now, that's decided under the probable cause standard, and the Commonwealth says probable cause is a low bar. I would contest that. Probable cause is not a low bar. It is higher than opinion. It is higher than reasonable suspicion. It requires specific articulable facts, trustworthy facts, and those were not present in the complaint application in this case. The complaint application simply does not contain any trustworthy factual evidence supporting the element of intent to distribute cocaine.
Well, can I ask you this? So let's say counsel had filed a motion to dismiss and it was allowed. Couldn't the Commonwealth have filed a new application, a more robust application with the same charge?
That would be speculation, Your Honor.
Well, so we
The
don't,
robustness of it,
plea counsel's affidavit doesn't say anything about this issue. So we don't know what additional information the Commonwealth could have presented and what counsel knew about it. So how can we say it was ineffective for not filing a motion to dismiss?
because the motion to dismiss is based on the four corners of the complaint application. So the test is, in the case law, Ortiz for motion to dismiss.
But if counsel had information in his possession that would have and he would have thought that the Commonwealth could have filed a new, more robust application that would meet the probable cause standard, why would it be ineffective for him not to file that motion?
Because
If he knew that the deficiencies could have been rectified?
Because he files the motion, the complaint is dismissed, and there's the benefit to the client. He doesn't know what the Commonwealth is going to do. Trial defense
We don't know
attorneys-
that. We don't have any information in counsel's affidavit about what he knew at the time.
About what the Commonwealth would do?
About what other information the Commonwealth had in its possession to support distribution. So let me ask you another question, and this relates both to the motion to dismiss and motion to suppress. So at the time he pleaded guilty in this case, he was already convicted in the Superior Court case, right?
That's correct. He pled guilty in November, the month before.
So couldn't he have made a reasonable decision, since he's already convicted and serving time, that he was going to take the deal that was on the table in this case? Because the earlier case was also a deportable offense, right?
The question is not deportation, if I can jump to that issue. It's relief from removal. He was already facing
The
removal.
earlier
The removal order
case
had
that
40
he was already convicted of in the Superior Court case, that was a trafficking conviction, right?
Correct.
So that would also mean he would not have discretionary relief from removal.
Correct.
Okay.
I'm sorry, I don't understand what deportation has to do with withdrawing the motion for a guilty plea. We're looking at this case that's before us, and the question is, did he do something he should have, did he not do something he should have done, the lawyer, and would it have achieved something of value, whatever the phrase is from Safarian, the prejudice prong, the second prong of Safarian. And it seems to me that if you can get the charge dismissed, you've achieved something of value for your client.
Exactly, Your Honor.
Regardless of whether, because that's what we're looking at. We're looking at this case and whether his guilty plea should be withdrawn, not whether he would still be deported. My
he
guess
knew-
is he will still be deported. I mean, if indeed he's in federal prison on a drug charge, the likelihood that he will not be deported seems close to zero. But that's not what we're here to worry about, right?
Exactly. We're focused on this case and the benefit that he would have received from dismissing that charge. And of course, he had two other charges. He had the civil infraction speeding and he had the OUI charge. So it's very likely that this drug charge may not have been even brought back. The Commonwealth may have
But
simply
isn't the
proceeded.
benefit of pleading is that he got a concurrent sentence with the time he's already serving?
Well, the concurrent sentence was a House of Correction sentence against a prison sentence of 6 to 8 years. So you could also argue that he had nothing to lose by,
Well, maybe, I mean, but he knew at the time that he pled that he wasn't going to serve any additional time by pleading guilty in this case, because he was already serving time on the earlier case. So without hearing from plea counsel about the decisions that he made and the discussions he had with your client, how can we say it was ineffective?
because the case law does not require an affidavit from plea counsel on the issue of failure to file a viable motion, whether to dismiss or suppress. That is, if the motion would have been successful and it's outcome determinative, the charge goes away.
Because there could never
That
be a
is ineffective.
strategic reason not to file a motion to suppress.
Exactly. There cannot be a strategic reason not to file an outcome
What if
determinative
he were to
motion
come?
depress-
What if he were to come?
dismiss or suppress.
What if he were to come in and say, I looked into this issue, the motion to suppress, and I decide, well, it's arguable, but because he's already serving time and he's going to get a concurrent sentence, I'm not going. I talked to my client, and we decided to take the deal. Why is that unreasonable?
It's unreasonable because he's pleading guilty to a felony, a 10-year felony that goes on his record and has collateral consequences. If he can get it eliminated, there's no reason not to have the contraband suppressed. There's no reason not to have the charge dismissed.
Which is why the silence of Attorney Dominguez's affidavit on this point and the motion to suppress is somewhat stunning.
As I said, Your Honor, it's silent because it's irrelevant what he thought about it.
Well,
It's
but you're
failure
telling
to
us
file
that
those
what's
motions is-
relevant is whether or not he had a viable motion to dismiss and/or a viable motion to suppress. I would
That's the only
think
thing
that
that's
trial
relevant.
counsel or plea counsel would have a lot of information about that. And the fact that it's not that you don't have an affidavit, you have an affidavit that says nothing about that.
That's correct, Your Honor, because as I said, the focus in the case law is on the viability of the motion,
All right, so let's
not
talk
on
about the motion to
counsel's
suppress for a minute.
strategy.
Are you saying that a paper towel can never be a container? You can't scrunch something up, that's a legal word, scrunch something up in a paper towel and conceal it?
But that's not what I'm saying, Your Honor, respectfully. That's what the SJC said in Alvarado. Alvarado said that a coffee maker in a coffee maker box is not a container. Now, we all know a coffee maker is a container because it contains coffee. If it weren't a container, the
Well,
coffee
the water
would be
well
all over it.
contains water.
Contains water, contains coffee, contains
So he
coffee
sees the
grounds.
glass case, he can open the glass case.
He can open the glass case is a container,
He sees the scrunched up
correct.
paper towel, and then
Yes.
what's he supposed to do?
He's supposed
Get
to
a warrant?
inventory it, or if he doesn't have.
Inventory it and say scrunched up paper towel, but I didn't open it, so, I don't know, there could be fentanyl in it that could kill me, but I'm not going to open it because it's not a container.
What you're talking about is an investigatory search. He may do an investigatory search with probable cause,
Okay?
but
So-
that's not an inventory search, which is what he was claiming to do.
He inventories it and says scrunched up paper towel. Mm-hmm. They tow the car back to the barracks. And then what? To Judge Rubin's question, do they then get a warrant for the paper towel?
If he had probable cause, he could get a warrant under the
They
automobile.
didn't.
If they, if
Towel
it's,
just sits there with the drugs in it, and it goes back to him when the car gets released.
Just like all the locked containers that are
Anything, yes.
in his car also that can't be searched under the policy.
because the inventory exception is not a pretext for an investigative search. It's not a basis.
I'm trying to figure out what were the police supposed to do. I'm trying to learn.
The police are supposed to develop probable cause. If they have probable cause, they can get a warrant and search it. Or pursuant to the automobile exception, they can just have probable cause and search it. But going to my first point, he didn't have probable cause. There was no probable cause in this case. No probable cause to
Wouldn't all
search
this
that.
have been great in plea counsel's affidavit?
Well,
I'll let that go.
okay.
No,
I sort of see the point with respect to the motion to dismiss. They certainly can get a new indictment for simple possession. I don't know what the penalty for simple possession is, but it's not concurrent with something you're already doing. So there's some risk that if you don't take this great deal and you go back and you do all of that, that now the somewhat annoyed prosecutor is going to come and say, like, yeah, that deal's off the table. Why don't we see, simple possession is, I don't know what it is, a year, or, I mean, it's cocaine, it's not marijuana, I don't know what the penalty is, but it's not zero. So I can see how that might be strategic. But the motion to suppress gets rid of any drug charge. So I don't see how it can be a strategic decision not to bring a viable motion to suppress.
I agree, Your Honor. And the case law is clear. Cases after case says failure to file a viable motion to suppress is ineffective assistance of counsel, full stop. There's no, well, counsel may have had a strategic reason not to do so. No, that's, especially if it's an outcome, in a drug case, failure to file a viable motion to suppress the drugs is ineffective
so
assistance of counsel.
you're saying there is no situation in which a failure to file a motion to suppress, I mean, I don't really know what viable means. It means it's arguable or?
I'm taking that from the case law.
Right, I
Viable,
understand.
think,
Right,
is
so
with-
failure to file an arguable, dispositive motion to suppress can never be strategic. That's what you're saying.
Yes, that's what I believe the cases say.
But this case seems more than viable. I mean, I don't understand Alvarado, and I'll ask your colleague about it. I would have thought that whatever that was, the SJC would have overruled it at some point, because it's incomprehensible to me. But there it is. We're bound by it. And I don't know why a policy that says closed container means that you can't, if you open the box and what you find is a coffee maker, you can't then look in the well of the coffee maker, but that's what it says. And I don't see how, and that was an obvious container, and indeed it had a ton of drugs in it. I don't see how, if you can't open the coffee container, you can unfurl a crumpled up paper towel. So, I mean, it seems more than viable to me. It seems like it's a winning motion. Now, maybe the SJC on appeal would reverse it. We can't even.
I agree, Your Honor, and I would just quote, I cited this case, Rosario Santiago, in my brief, but there's an excellent quote in a footnote in Rosario Santiago, footnote 22, that's 96 Mass App Court 166, and this is a 2019 case, much more recent than Alvarado, and this is by Justice Hanlon, where she writes, Alvarado establishes that just because an item found in a car can, for some purposes, be considered an unlocked container, it does not mean that police necessarily are justified in looking inside it as part of an inventorying of the car's contents. So I think
But
that's...
in that case, we held that a fast food bag that looks like trash can be opened, right? How is
Yes.
that different from a crumpled up paper towel?
Well, a bag is a container. I think in
So,
Rosario Santiago,
What if it was a piece of paper folded origami style and like in a pouch? I mean, how is the officer supposed to know which counts as a container?
I think we're looking at these platonic ideals of containers. A box is a container, a bag is a container, a cup is a container. But anything that can contain is not necessarily a container Otherwise, you'd be able to drive a truck through the inventory exception because the state police have drawn it very broadly. Police are authorized to open everything that can contain, every container, and the court has stepped in and said, well, hold on, not everything.
Well, it's a construction of this particular inventory policy. No one has said you couldn't have an inventory policy. I don't know how broad it could be. I was a little surprised to see that locked containers can't be opened. If what you're looking for is a bomb that someone has left in their car that might endanger people, I don't know why you wouldn't be able to open every single thing to make sure there isn't one. But that's not what they wrote in this policy. And it's the very same policy that was construed in Alvarado.
Yes, exactly, I agree.
So can I ask you, going back to the question that Judge Shin has been pressing about strategic decision, we know he got a 9-month House sentence in this case, concurrent with a Superior Court sentence he was then serving. Can we consider as part of this analysis the fact that he's now doing a federal sentence until 2032, as in terms of strategic decision by plea counsel?
No, because it wouldn't have been a factor for plea counsel to consider in 2009.
So timeline-wise, do we know in the record when charges were brought out of Florida?
2015 was the date that those charges were brought.
And what date did he plea?
2016, I believe.
So they were filed, but they hadn't been resolved in the federal charges?
Federal charges, 26,
Pending, okay.
and this is 2009.
Your time has expired, but I actually have another question. If anyone else does, that's fine too. I feel like I may be misremembering. The Commonwealth raised some issue about whether, about the name of your client versus the name on, or am I mistaken about it? There's some issue about whether this is the same person who was being deported or something. Am I just making that up?
The Commonwealth raised some issues about the date of birth, I understood in their brief. I think it's...
And
there's
his name?
And name, okay. So the name and date of birth were not contested below and are corroborated by the Commonwealth's filings. The Commonwealth has filed material that frankly has not been impounded but should. DJCIS or DCJIS material that lists my client's names, dates of birth, and those are official government records that I think would corroborate.
Do we have anything in the record about assuming, and I have no idea, that your client wasn't deported and has since re-entered the United States, presumably unlawfully? There was a pending removal proceeding, and it had gone against him because he didn't show up because he was in jail.
That's correct.
But I gather we have no record that he was actually deported as a result of that?
That's correct. I don't have that. That's not in the record.
Was there an ICE detainer when it might not have been ICE back. Oh, no, it was already ICE. Was there a detainer put on him while he was in state custody? Do you know?
I am not sure of that because the state case, the other Superior Court case, was a Dukin case he was then released in 2012 pursuant to a Dukin motion, and that motion for new trial was filed in that case. That charge was dismissed, and then he repled to time served and was released. I'm not aware of his deportation removal status at that point.
Okay.
Yeah, just one question. On the Padilla issue, doesn't the resolution of that claim in this case depend on what happens in the Superior Court case, which I understand is on appeal?
Superior Court case is on appeal, that's correct. The Padilla issue, as I understand the Clark factors, other cases are not a consideration. You have
No. So at the time he pleaded guilty in this case, he's already been convicted of a trafficking offense in the Superior Court case.
Right.
Had he been told that that's going to subject you to mandatory deportation with no discretionary relief, that is relevant to at least the prejudice issue in this case, right? Whether he would have chosen to go to trial. Because he already knows, if we assume he already knows that this earlier conviction is going to subject him to mandatory deportation, then that matters, right?
It does matter, but we don't have a basis to assume that because we have an affidavit from trial counsel on this point. I have that, where counsel did not recall inquiring further into immigration issues.
In this case.
In this case,
Right,
yes.
but we don't know
And
what
in that
happened in
case
the
as
other
well.
case. Well, we don't know that. We don't have that case in front of us, right?
True, but I can tell you as the attorney in that case, the lower attorney, the plea counsel, filed the same affidavit.
Is
in
it the
that
same
case.
attorney?
It's the same attorney.
Did you ask for these two appeals to be heard together?
The other appeal, I wanted the appeals to be heard expeditiously, and the other appeal is now ready for assignment. It has been fully briefed, but it raises different issues. So I think it's appropriate for them to be considered separately.
All right, your time has expired, although no. All right, thank you very much.
Thank you.
Interesting argument. We will hear next from Attorney Paris.
All right, good morning. May it please the court. Molly Parrish on behalf of the Commonwealth. Today we're asking that this court affirm the motion judge's denial of the defendant's motion for a new trial. If the court would allow me, I'll first start with the defendant's Padilla claim and discussing the prong one, that the motion judge was entitled here to discredit the defendant's self-serving affidavit. There were a variety of reasons, including that this defendant had various dates of birth, went by different names. He was also subject to removal proceedings during the pendency of this case, and he was represented by the same attorney in his superior court case and in this district court case. This defendant also had state and federal drug convictions that pre- and post-date this plea. But then looking at plea counsel's affidavit,
Get there, could I, on this topic of names and dates of birth, you do state in your brief at page 41 that this individual on 2 occasions represented himself as a citizen of the United States for the purpose of obtaining a United States passport. How is that relevant on the Padilla issue?
I think it just goes towards his willingness to lie and the motion judge's assessment of the defendant's credibility in raising his claim that he didn't receive the proper immigration advice. I think it's also worth noting that this defendant filed his motion for a new trial over 13 years after he pled guilty. So there is no plea colloquy, and I think that the court can draw an adverse inference from that. But turning to plea counsel's affidavit, that also doesn't satisfy the defendant's burden of showing that he did not receive the immigration advice here. Plea counsel just avers that he doesn't recall a specific conversation about the defendant's immigration status, that he knew that the defendant wasn't a U.S. citizen, and that he knew his plea in this case would produce negative immigration consequences. But I don't think more would be gleaned here from an evidentiary hearing where counsel doesn't recall, and there's nothing.
But it's not all non-recollection, right? He also says he made no inquiries into avenues of relief available to the defendant for the immigration consequences of the plea. Now, I'm not saying that's the most beautifully written sentence in history, but it doesn't say I don't recall making any. It says I didn't make any. How can he know that this is a De Jesus almost certain deportation case without making inquiries about what the consequences will be?
Well, I think here, Your Honor, it's interesting because the defendant he pled guilty in his superior court case a month before he pled guilty in this district court case.
So
and
what?
That matters because the defendant is not challenging. The defendant filed a motion for a new trial on his superior court case, which is in the docket in the.
Do you have a case that says if you heard about your immigration consequences in some other case, you don't have to be told in this case?
No, I'm not saying it eviscerates counsel's obligation, but I think when we have that, we also have the plea sheet where at least
It says may. The plea sheet says I told him that he may have consequences, and De Jesus says that we don't use the green sheet anyway, right? I mean, there's case law about that too.
No.
But It doesn't even say he gave the proper advice.
I mean, well, counsel doesn't adver anything to his standard practices at the time. And I think regardless of what plea counsel told the defendant prior to his plea, the defendant here faced no new immigration consequences, given that he pled guilty to trafficking a month before in Superior Court, which was an aggravated felony, barred him from discretionary relief from removal, and made him subject to deportation.
That's only if he was told in that case about what the consequences were, right?
Correct, Your Honor. But as I was trying to get to before, the defendant...
And in the end, that conviction apparently was vacated. That can always happen. I don't know. We don't usually look at other cases. People come here. Now, this is an unusual circumstance because he's in jail apparently till 2032. And for more drug dealing charges. I mean, I don't see how anything he does in Massachusetts is going to eliminate that he is mandatorily deportable, but that's not the question. We get in some of these cases where someone years later faces an immigration consequence and they have 9 guilty pleas, they bring a motion in each one. Obviously, they have to win all of them if they're all aggravated felonies. You know what I mean? But we don't look at some other case and say there are no immigration consequences to this unless you have a case that says that, because of another case.
I understand, Your Honor. I think it goes to the fact that the defendant was likely aware, but regardless of that, the defendant hasn't satisfied any of the 3 Clark factors. This is a case where the defendant hasn't shown he had any available defense. There's no facts that he provides in addition to the arrest report as to what he would have brought had he proceeded to trial. There's no evidence that the Commonwealth would have provided a more favorable deal, especially where here he avoided a mandatory minimum. He received the 9 months in the House of Corrections concurrent with his Superior Court sentence. And also, he has failed to establish any special circumstances. Typically, special circumstances are found in a situation where the defendant has lived in the United States since he or she was a young child, such as in De Jesus, where the defendant had been here since he was 11 years old. He had maintained steady employment. Then it was his first arrest. And that's just simply not the case. And even beyond that, the defendant's ties to the community are only set forth in his own self-serving affidavit. There's no affidavit from his wife, his son, or his daughter, who are all United States citizens. And also, any claims that he's afraid to return to Colombia are undermined by his 2015 federal drug trafficking case, and that case involved importation of drugs from Colombia, and that's in the record appendix at Commonwealth Record Appendix 99. So unless the court has any further questions, I'll turn to the motion to dismiss just briefly.
One quick, before you get there. Why isn't he entitled to an evidentiary hearing at least?
I think for a few reasons, Your Honor. The first being that the motion judge has discretion whether to grant that evidentiary hearing, but also counsel avers that he doesn't recall that whether he inquired into the defendant's immigration.
So nothing more would come?
I don't think anything more would come.
Well, talented lawyers seem to drag information out on direct and cross. Maybe his affidavit was written in such a way intentionally, and that there is more to potentially be gleaned.
That's possible, and perhaps the motion judge may, in his discretion in a different case, had allowed an evidentiary hearing, but I think here where there's no averments as to counsel's standard practice at the time, what he would or wouldn't have told a defendant before pleading guilty, I just don't think on this record there's enough to sustain the defendant's burden as to whether he was entitled to an evidentiary hearing. But turning now to the motion to dismiss, the defendant here has not met his burden of showing that he would have likely prevailed on the motion to dismiss, and that's his standard. The probable cause standard is very low, and here...
Where's the probable cause that this is with intent to distribute?
So if you look at Record Appendix 13, there's 4 facts that are in the arrest report that go to the defendant's intent to distribute. That is the 9 grams of a white rock substance believed to be cocaine. And from that, the reasonable inference is that it was for distribution as opposed to personal use.
Why? I don't know anything about how many grams a person uses. Do you?
Well, Well, I think all reasonable inferences at this stage need to be taken in the light most favorable to the Commonwealth. And
Okay, and how is 9 grams? Do you have a 9-gram case?
I have Commonwealth versus Goldman, which is cited in my brief, and that was a case where 2.5 grams of crack cocaine,
How were they packaged?
it was in a single plastic bag
In that other case?
contained within the crumpled paper towel.
No, in the other case. I mean, if this were in tiny
Oh,
twists or something, then,
Oh, it
okay,
is.
then it's for sale. But this is just in a bag.
I understand, Your Honor, but there are some other factors, such as the lack of smoking paraphernalia. Again, that's a reasonable inference that where this was crack cocaine, there would need to
Are
be
there
some.
cases where no scale was found, no records were found, no money was found, and just rock cocaine? And I really don't have any idea how many, is 9 grams a lot, is it little? I have no idea. But how could I have probable cause if I have no idea? I mean, I've seen some cases where the value of it is put, and there's a place on the application, I think, for the value of it says of the property. I don't know if you would put it there. But if it said this is worth $9,000, then I'd say, oh, well, geez.
Sure, and perhaps the trooper could have included that in his report, but where all reasonable inferences are taken in the light most favorable to the Commonwealth at this stage.
Is there anything else given to, I know the records were all destroyed because this is 13 years ago. Is this the whole thing that's given to the magistrate? Just the police report? There's no opportunity for an officer to say, as they would say before a grand jury, based on my training and experience, I know that this is an amount that, people sell.
I think this is answering your question, but in the arrest report, the trooper says, based on my training and experience. So I think the clerk magistrate could infer that based on this trooper's training and experience, where he's laying out these 4 factors, the 9 grams, the lack of smoking paraphernalia, the apparent quality, and the suspect's
What does the apparent quality mean?
We have case law, Commonwealth versus Roman, that says that the high caliber supports an intent to distribute.
And what did they use to figure out the caliber in that case?
I'd have to go check, Your Honor, but
Probably testing it and seeing what percentage cocaine it is. Wouldn't you think?
that's correct, but that could be fleshed out at trial. And I think it's worth noting that all the cases except for Roman and Humberto H., which the defendant relies on, are all cases where the Commonwealth went to trial and expert in.
If the defendant had filed a motion to dismiss and it was allowed, could the Commonwealth have filed a new application with the same charge, fleshing out the details in the first application?
I think it could, as long as.
If you had some.
Yeah, as long as.
If you had some additional information, could you have filed a new application alleging the same charge?
So long as the complaint wasn't dismissed with prejudice. I don't see why not.
Would it be dismissed with prejudice or not?
I don't think it would be if there was additional information. I think the Commonwealth would be entitled to file a new criminal complaint.
Okay.
But I think regardless, too, the defendant isn't challenging the factual sufficiency of his plea. So I don't think it's necessary for this court to rehash whether all these elements were sufficient for intent to distribute, just whether on the 4 corners of the complaint was there probable
Oh, yeah, I'm just
cause.
wondering if you have a complaint application that's deficient, just doesn't allege enough details, whether you can do it over again.
I think if there was additional evidence, I think the Commonwealth would be able to file a new criminal complaint.
Can I ask about because time is short, I'm really interested in this question of the motion to suppress. That's actually the most interesting question, I think.
Yes, Your Honors. So turning to the motion to suppress, the defendant bears the same burden here, which is proving or establishing that he would have likely prevailed on the motion. And here, the trooper was well within his purview to open the crumpled up paper towel, which was contained within the closed eyeglass case.
What do you do with Alvarado?
Alvarado is distinguishable from our case because a canine dog was present during the search.
That's not what the opinion doesn't say because of the dog. The opinion says you can't take this box that you've opened and has a coffee, you can't take it out of the car and open the water well. Now, the water well I would have thought was a closed container, and maybe if I'd been deciding the case, it wouldn't have come out that way, but it did, and it's the SJC. A water well seems very much like a closed container to me, but you can't open it. If you can't open that because it's not a closed container, how is a crumpled up paper towel a closed container?
Well, the SJC in Alvarado wasn't willing to say if there's a canine dog involved in a search, especially where it involved an investigation of drugs, unlike this case where the defendant's pulled over for an OUI and then proceeds to conduct a lawful inventory search. There, a canine dog was present, and the Commonwealth said, no, the SJC said, no, that's too far. We're not going to allow.
In Alvarado?
In Alvarado, we're not going to allow.
And did the canine signal at the box or where?
Yes.
I mean, I'll have to look at Alvarado again. I didn't think that was a canine case, and it's been treated as, we have a case here saying closed containers inside closed containers are openable. And it has a footnote that seems to say that Alvarado stands for the proposition that a coffee maker isn't a closed container.
I think in that specific case, it wasn't a closed container for purposes of a lawful inventory search because the canine dog was present, and that made it an investigatory search. But also just to quickly address Rosario Santiago cited in counsel's brief, that was a case where the court found looking in a fast food cup and a fast food bag was within the proper bounds of a proper inventory search. So I think the same can be said here, where we have this crumpled paper towel that could have valuables. The trooper doesn't have to turn a blind eye, where that's also contained within a harder shell of the eyeglass case.
I know you're out of time, but I did have one question on this. So you said the question is whether he would have prevailed on the motion to suppress. So the standard is we're just to decide the motion to suppress as if it were brought today and is before us? Or let's say we were to say, well, he has potentially a viable motion to suppress. What happens then? The plea is vacated, or does it go back for some sort of hearing?
I think the plea is vacated, but I don't think this court needs to get there because filing a motion to suppress in this case would have been meritless, and so there's no ineffective assistance of counsel.
So we're just to decide the motion to suppress as though it were presented before us today.
I think the defendant here has the burden of showing that he would have likely prevailed on the motion.
Likely prevailed, do you think is the standard?
Yes, that is the standard articulated in Diaz, which is cited in my brief.
So 13 years later, a defendant can come in and say, hey, if my counsel had filed this motion to suppress 13 years ago, I likely would have won, and then we have to vacate the plea.
I think it depends.
Without any hearing on what counsel, that's irrelevant.
I think it depends on what the motion to suppress involves. Here, where it involves an inventory search, it's more of a question of law. Did the trooper exceed the bounds of a proper inventory search as opposed?
I get that's depending on the issue raised in the motion to suppress that was never filed. There might have to be an evidentiary hearing where the officer comes in, testifies, because this is an inventory search, maybe not. Mm-hmm. But there's never going to be any situation where it would be a strategic reason not to file the motion to suppress, even if maybe he would have won.
Oh, it could definitely be strategic not to file a motion to suppress. In this case was one of them where this district court case was trailing behind his more serious Superior Court case.
So then why would we vacate the plea instead of remanding it for a hearing?
The defendant hasn't requested remand, and I don't know if you remand, I'm not sure what an evidentiary hearing.
Counsel on the stand, hey, what were you thinking? What discussions did you have? I mean, I don't know.
But
anyway.
Your time is up, but I don't really understand what it means. It's following this other case. How can pleading guilty to possession with intent to distribute, if the evidence shouldn't, like, is unlawful, there's no evidence of it that can come in, how can that be a strategic decision?
My point was, Your Honor, that the defendant was trying to wrap up this district court case as quickly as possible, given that he had a more serious Superior Court case that predated and was going along with this district court case in time. So I think considering, his client's circumstances at the time, it was reasonable to not drag out the district court case by filing all these frivolous pretrial motions.
Okay. All right, very good. Your time has
Thank you.
expired. Thank you very much. Excellent argument. The case is submitted. Do you want a break? Yeah. All right, we are going to take our traditional mid-morning break. We will resume our sitting in about 10 to 15 minutes. And so until then, court is in recess.
Session, please be seated.
Welcome back. We will resume our hearing this morning with number 23-202, Department of Children and Families versus Mother and Others. I gather that the appellees will be splitting their time, Attorney Fowler 10 minutes and then Attorney White 5 minutes, is that correct? All right, and I would remind all attorneys, and I suppose us as well, this is an impounded case, so be sure to use pseudonyms for the parties' names or just, mother, father, et cetera. Father 1, father 2, et cetera. And with that, we will hear from Attorney De Palma.
Good morning, Your Honors. May it please the Court. My name is Valerie De Palma, and I represent the appellant mother. In this case, the trial judge improperly terminated mother's parental rights to her two children because DCF failed to prove by clear and convincing evidence that she was unfit to parent them. We're asking this court today to vacate the decrees terminating her parental rights and to remand the case for a new trial. I'm going to focus sort of on three general areas to hopefully impose some structure onto the unwieldy facts. And this is a case that is very intensely rephrase it. It's very fact-intensive, as I'm sure you're all aware. The three issues being mother's mental health and volatility, the second issue being her ability to meet the children's special needs, and the third regarding the incidence of abuse and domestic violence. Turning to the first issue, the trial judge found that the evidence of mother's volatility indicated that she was not fit and that her prior acts of volatility could be used for prognostic value to determine that she would not become fit in the near future. But the bulk of the acts on which she relied were stale. Three of them occurred in 2018, one occurred in 2019, and the trial in this case was in 2021. The remaining two acts involved the mother's statement to the son that he had lied about the incident leading to the scratch on his nose and the child becoming upset at this. And the second was mother's text message to the foster mother, who is her cousin, concerning the cancellation of a visit because the foster mother's parent had passed away. And while neither of these statements was advisable, they simply don't rise to the level of a grievous shortcoming warranting termination of parental rights.
Well, I mean, the statements to the boy were, I wouldn't call it unfortunate. I mean, I thought I wouldn't characterize that as unfortunate, accusing the boy of lying to the point where he's upset. That seems to me to be fairly serious. But putting that aside, evidence isn't stale if it's a pattern, right?
True, but I think here, the pattern, as I said, three in 2018, one in 2019.
It's a pattern of removal, reunification, compliance with services, removal again, reunification, right? I mean, there's always going to be a lapse of time between removal and trial, right?
Correct.
Yeah, so let's say she gets another chance at reunification and then the child's removed again, there's going to be another lapse. And so, not you personally, but the mother's counsel can always come forward and say, well, that evidence is now stale, right? So that's why if it's a pattern, then we don't consider it to be stale.
True, but I think the pattern has attenuated over time. Let's put it that way. That, yes, I agree. The statement to the child was, clearly it made the child extremely upset. But is this on par with previous acts of volatility, which, again, the reasons the children were removed, if you'll recall, were one, she was psychiatrically hospitalized following the disclosure of sexual abuse by the son, by his father. The second removal was a result of her getting into an argument with another woman in the DCF lobby. And the third was the child going to school with a scratch on his nose and having said that his mother threw something at him. I mean, again, but we're talking about taking someone's kids away here. And I agree, yes, she's flawed. She made mistakes. But this is someone, again, and again, this is something the judge, I think, did not treat even-handedly here. She is trying. She has been trying. She's done everything they asked.
The judge acknowledges
She acknowledges
that
it.
she has completed every task, and I have to say, I think that's very impressive. We don't often see cases in which the person actually completes all of these tasks. But unfortunately, completing the task doesn't automatically render one fit.
No, I agree. You have to demonstrate.
Well, actually, the
The knowledge you've
Commonwealth
gained.
has the burden, right?
Right.
But one may be unfit despite having done all of that.
True, I don't disagree with that point, but I think what
I think
DCF
the
was
judge
looking
found that
for.
even her own expert basically said I know the DCF argues this, that the level of assistance she'll need to care for an autistic child, just for example, is beyond her capacity. Not that she isn't well-intentioned.
But I think anybody who has an autistic child, whether they're in, DCF involved or not, needs help. It's hard, right?
But it's more than that, right? We have, I don't know if it's a formal, as to the younger child, failure to thrive, but there was some pretty significant concerns when these children were first removed, and then as my colleagues have said, when the child goes back and forth, there's this regression each time. I know you say that those are clearly erroneous, but failure to thrive is a pretty significant diagnosis.
Well, wait, no, Judge, there was never a diagnosis of failure to
There
thrive.
was
That
a
was how she
2-year-old
cared.
who couldn't stand.
No, I'm not arguing
Right,
that
or,
that's.
I mean, you may not call it, I know there's no diagnosis, but it's, right, doesn't speak, doesn't cry when hungry. It's a bad situation.
Yes, I acknowledge that, but failure to thrive is a
Right.
diagnosis of a child, like, not growing, of
Okay,
not.
well, I
that-
don't know what you would call it,
that's
but the.
entirely, and her use of that is confusing.
Not developmentally appropriate, I think, is probably what the court
Yes,
says,
she was
yes.
behind on her developmental milestones. And I'm not disputing that. However, I think, again, she has demonstrated through her participation in therapy, through her getting on medication, staying compliant with medication, completing classes. I mean, really what DCF wants is an admission. They want her to say, how they phrase it and how the judge phrases it, we want her to acknowledge her role in the children's removal.
And then you cite us some article that says that's not essential.
Well, yes, the expert testified to that, but I think that what we should look at what she's done, okay? It's not parole, right? We're not here, yes, and I'm not saying that progress or in therapy may partly be acceptance of your previous wrong, but I think in this case, it is not necessary to determine that she gained from her services. And I'd like to turn more specifically to the expert's testimony, because our position is that it was abuse of discretion for the judge to have rejected it pretty much wholesale based on her conclusion that mother had made 3 false statements to the expert. The first being that she had heard voices. She had told hospital personnel that she heard voices when she was being admitted in 2017. And she made this finding based on mother's refusal to answer a question posed to her on cross-examination by the Children's Counsel. Her lawyer interjected, I think counsel's thinking, privileged information, and the judge responded, I'm going to allow the mother to refrain from answering this question. So in my main brief, I responded this as she sustained the objection. There's no evidence.
This is the same judge who then, the trial judge both sustained the objection and therefore didn't have any substantive evidence, you're saying?
Yes.
And then at the end said that this was an important...
Well, yes, and she, from that refusal to respond, inferred that the mother had in fact...
Is there no other evidence in medical records or anything else before the court?
No, they were not admitted. Counsel was, I assume, had to have a good faith basis to ask the question.
Yes, that's right.
So had he wished to, well, the first question is, none of that happened. And the judge just said, I'm going to allow the witness to refrain from answering the question.
Right,
And
there
then
wasn't
in her finding,
we don't know what the judge actually ruled. It's all inaudible.
not all of it.
Well, most of it is.
The statement that she specifically says, I'm going to let mother refrain from answering, and that's at volume 4, page 82. After that, it's inaudible. But her
And
finding...
there's something, I read the dashed lines to mean that that was not the end of the sentence.
No, true, but that first sentence is intact.
No, I read that dashed lines to mean that there was a later part of the sentence that was inaudible.
True.
Okay.
Yes, but I think based on what she then found was that I am going to infer that mother did in fact tell hospital personnel.
But there's other things too. She dissembled enough to the expert to invalidate at least one, maybe two, at least one of the tests. Now, we have cases where people do evaluations. I can't say that I remember seeing these specific tests mentioned by name before in other cases. But if you are dissembling sufficiently that it invalidates a test, it does call into question the value of the self-reported information you're giving.
Well, I would contest imposing a legal judgment on what is a clinical judgment.
Well, at the end of the day, the expert was able to conclude that she had, whatever this is, tumultuous personality.
Well, she said according to the test, it suggested that she may have this, but she also clearly set some limitations on that finding, which were that it's not a DSM diagnosis, it's a personality style. Mother may have some of the qualities, may not have others. Some of the qualities are actually very positive. Being a perfectionist may be, unpleasant to live with someone like that, but they're, can be trusted, are reliable, et cetera. I just think she was focused, the judge was focused on sort of the parts of the expert's opinion that were negative. And the part about her having faked good on 2 of the 4 tests, only one of which having been invalidated, again, was a clinical judgment. It's response bias. Anybody undergoing a parental evaluation is going to, myself included, probably try to make myself look good. And I'm not doing it necessarily consciously. It is people poll racist, even anonymously. That's the same bias. It's a response bias because you're motivated to provide socially acceptable answers. It's the same thing.
Well,
So I
you
think
only
we can
have to
only-
fake them if you don't have socially acceptable answers.
Well, I mean, but the point is, I don't think this court, based on this record, you cannot, and based on the expert's testimony about how she treated those, I don't think the court can use it as character evidence of untruthfulness. It just simply, I suppose if every single test was invalidated and the expert felt inclined to say this person is malingering, but that's not what she said. What she said was, her response is common amongst parents in the middle of high-stakes custody disputes, which is entirely understandable. And I think that the judge, again, she was focused on that. She, in fact, called the false statements that she found, she then said mother was presenting herself in a false positive light. That is error. That is somebody not understanding what response bias is. You cannot use clinical terminology to characterize a legal judgment. Second, she was clearly treating the opinion, without, not even-handedly, not looking at all the positive things that the expert found.
Okay,
including-
your time has expired, although if there are further questions, we have your excellent brief as well, and of course, so
Thank you, Your
it's
Honor.
not just this. Thank you very much. We will next hear from Attorney Fowler.
Good morning, Your Honor, and may it please the Court, Assistant Attorney General Erin Fowler, on behalf of the Department of Children and Families. We are asking this Court to affirm the judgment of the trial court, who did not want to take a chance on Mother a fourth time. Although Mother indeed participated in services, it was not enough where she was not able to understand or meet the needs of her children, especially her young son who has special needs. I'll first turn to evidence of Mother's unfitness. The court did not abuse its discretion in holding that Mother is unfit. First, the court properly concluded that over the course of several years, Mother displayed a pattern of volatile behavior that often put the safety of her children at risk. In factual finding 14, the court provides 6 examples of Mother's volatile behavior, although I'll add that these examples are meant to be illustrative and they're not exclusive. So for example, there's a 2021 incident that we talked about in which Mother disrespected the foster mother's religion after the foster mother canceled the visit due to her pastor dying. There's a 2020 visit in which Mother, as Judge Blake noted, in a very serious manner, told her son, "I'm in this situation because of your lying," which upset her son, and the foster mother had to, bring the mother outside of the room to sort of let the situation calm down. There's, of course, the 2019 incident in which Mother threw an object at her son's face, causing a 1-inch cut, and then there's 3 2018 incidents. One
She
in which...
never found that it was the mother who threw the object, right?
Sorry, could you repeat that question?
The judge never directly found that the mother threw the object, right?
The judge didn't credit Mother's version of events, and in the conclusions of law sort of uses this language of the cut occurred while in Mother's care, so it's still a sign of neglect from the mother.
Okay, but she never, she says appears to have thrown, so she's never making a direct finding, right, that mother
That's
threw the
correct.
object.
Correct. So of course, there's the 2018 incident in which Mother got into a verbal altercation with a stranger in the DCF lobby, and her 5-year-old son held on to her tight. There was a 2018 series of confrontations between mother and daughter's daycare providers that resulted in the daughter being terminated from daycare. And the 2018 parental visit that had to be terminated early when Mother repeatedly raised her voice at the social worker. There are, of course, other examples of this in the record. So for example, there's the incident with her own expert, in which the first 5 minutes, the mother wouldn't let the expert talk. I would also point the court to Nicolette Hayes' testimony, where she talks about how, over time, she found it really difficult to engage with mother. There was an incident in 2019 where mother kicked her out of her house after she had asked about mother's potential boyfriend. So DCF would posit there is ample evidence in the record to support the judge's determination that mother had volatile behavior over the course of several years. I will respond to my friend on the other side's argument that many of these pieces of evidence are stale. I think the way that mother talks about staleness in her brief and in this argument is that a very sort of clear-cut, if anything happened 3 years ago or more than 2 years ago, the evidence is no longer relevant. Staleness doesn't go to relevance, it goes to the weight of the evidence. So here, and she cites to adoption of Rona, and that case is easily distinguishable. And Rona, that stands for the proposition, in that case, mother had she failed the drug test. I think it was 3 or 4 years before. But then all of the evidence since then indicated that mother had been sober and engaging in services. That's not what we have here. It is not an incident where, mother blew up 4 years ago and then since then she has been, perfectly calm in every engagement with DCF and with service workers. This is an incident where, as Judge Shin noted, there's a consistent pattern, and evidence is not stale, where there's sort of an unbroken pattern, or not unbroken, but a pattern over several years that shows that the evidence, even older evidence, has continuing vitality.
Can you just clarify for me?
Yes.
There was not a formal diagnosis of failure to thrive, right?
That's my understanding.
So what do we know about the children's special needs?
So are you speaking just specifically to, for example, the son's autism or the environmental
I know
neglect?
we had early stuff like the cyst on the kidney and whatnot, but basically at the time of trial, what their ongoing needs were or how those needs changed over the course of the case.
So I can say at the time of the trial, as you said, there is evidence that the son has autism. He's engaged in weekly services. The daughter has this cyst on her kidney that requires quarterly monitoring. And over the course of the case, there is evidence that the daughter had some serious sort of developmental delays. It doesn't seem that that was an issue at the time of the trial as much, although there was some evidence that she would regress after seeing mother. And they also, both children.
How do we
at the
know
time-
in these cases? Actually, I'll let you finish your answer. I'm sorry.
What do we know about what was required for example, the younger child to be able to hold her own head up, sit, walk, talk, cry? Like what interventions were given?
So it's not clear. I don't believe that she engaged in sort of formal services to.
The environment.
It was the environment. And she did, I believe it was in 2018, see once the foster family, after the second removal, had noticed that, her legs had no muscle tone, she wasn't crying, she wasn't trying to walk or stand, did have her see a neurologist who determined that it was likely environmental neglect that caused this.
Thank you.
Was she placed, the younger child, always with this same foster family or at first someplace else?
It was not always with the current foster family, no. They moved to the current foster family in the summer of 2020.
And I read something in here that referred to other children in the foster home, but there's not much detail. I mean, no one's contesting the plan, I guess, so maybe that's why there isn't. There are other children in the home?
They're older children. I know that at the time of trial, I believe there were the foster mother had 3 children who were sort of older teenagers. I think one had already moved out of the house. I'm not sure where the remaining 2 are.
Okay.
Would you agree that these instances of volatility that the judge lists, that would not be enough alone to establish unfitness? Because, honestly, some of them don't seem to me to be all that. Mm-hmm. I won't say they're not serious, but it doesn't show unfitness to parent. For instance, her argument with her cousin about the priest dying. I mean, how does that really go to unfitness?
I think, so I hear your point, and I think, looking at the text message example, the pattern that we see over and over again is that mom is unable to sort of stop and think and regulate her behavior in a way that causes damage to her children or a relationship with the relationship with the children. So for example, I think that text message example is significant because after that, foster mother said, I'm done supervising visits in my home. I'm going to have a DCF supervise these visits.
If you didn't have the evidence of the developmental delays, would this be a termination? I don't know.
It's really hard to say
Yeah.
from this case. I mean, I think I acknowledge this is a more difficult case. I think both counsel and their closing arguments at trial acknowledge that this is challenging. But I think what's important here is that we do have that evidence of the developmental delays, and we do have the volatility. I do also want to acknowledge my friend on the other side's argument about mother's sort of failure to acknowledge or understand her own role in the behavior of her children's removals, because I think there's an important distinction. The judge was very careful about this in her findings. If you look to conclusion of law 24, the court isn't saying, admit this or you don't get your kids back. The court's saying your refusal to admit this is harming your son. And she looks at the example of mother calling her son a liar. So in conclusion of law 24, she says, regardless of how this scratch was caused, as his parent, mother is expected to moderate her behavior and support his emotional health, and instead she kept reigniting his distress by insisting that he lied. So I did want to add that gloss on that behavior.
I don't see how you can say that without reaching a conclusion about whether he's lying or not. Parents punish their children for lying. Much worse than just insisting you're lying, right? I mean, I'm not saying it wouldn't be maybe more emotionally healthy to say, I see that that's how you see it, or, whatever, right? But without making a finding, I don't see how you can say saying to him he's a liar is harmful to him.
I mean, I think especially...
I mean, again, I'm not saying that, but I also don't think this case turns on that. But let me ask you this. If it does turn on the child's development, you say, or the judge said, these some of the delays at the beginning are clearly the only place the child has been is with the mother. But this regression, can we tell from the record whether the regression occurred during the time the child was with the mother, or might have been the result, and I know nothing about this, I would need an expert, I don't know anything about how this works, simply taking the child away from the mother and placing them in a foster home might, I suppose, cause regression. And that's how your friend characterizes this. Can we tell which it is?
I see the point. It is a bit challenging. I think, so it's often the foster family seeing that, so for example, after the third removal, the foster family sees that the son has experienced a regression from the last time that he was in foster care. So I think, in circumstances like that where the family is seeing, this was the child that we saw then, he was in mother's care, now he seems different. I think in there, it's a reasonable inference to be drawn that regression happened while in mother's care and was not necessarily due to removal. I think that's the inference that this judge made, and I think the judge didn't abuse his discretion in making that.
Were there social worker visits while the child was with the mother?
Yes, I believe there was.
Well, I mean, I have to say, I don't know if you communicate with the people who do the clinical work here. It would be very helpful to us because I've seen lots of cases where the assertion is regression is caused by the parent, and it's very hard to tell. Usually it's during a visit. It's very hard to tell whether it's the removal from the parent or I don't know if you can tell with a little kid even, but if the regression were noted during the time the child was in the mother's care, then that would be different.
I mean, the regression after visits, we see that argument a lot. Don't you need expert testimony to make that argument?
I don't think so, Your Honor.
How do we know that the regression doesn't happen because they've just been taken away from the mother? The visits ended. I mean, I don't know.
Right.
Right?
So the evidence on the regression after visits was the foster care mother explaining that, after I have the child in my care, I see one child, and then she interacts with her mother, and I see, this is what I see after she interacts with her mother. I
Right,
think,
but it doesn't mean the mother necessarily did anything bad during the visit, right?
right.
Well, the child could be scared that they're going to be taken back to their mother, and that will be disastrous for them, and they may react. Or maybe, and again, this is why maybe an expert is necessary, or maybe they think, oh my God, my mom, and then they're told like, well, your time is up. You know what I mean? And they're devastated by that. I don't know how to figure that out.
It's challenging, and I think in this case, what I can say is this was the determination the trial judge made. This was a reasonable inference to be made from the evidence. I think, even if we would look at the evidence a little bit differently or ask for an expert, I don't think doesn't necessarily mean that it was error for the judge to conclude this. And I think, Mother raises in her reply brief that, this could be for a number of things. I don't think that wasn't raised at trial. And I don't think when that's not raised as a potential alternative explanation that DCF then needs to sort of proactively present evidence to exclude all potential explanations. I think it just goes down to what the reason was.
No, but
maybe
these
that shouldn't be
obvious ones, if
argued.
you can't tell the difference.
Maybe it just shouldn't be argued as evidence of unfitness.
Well, unless you can say more about it.
Well, I think it,
But yeah.
I'm sorry, go ahead.
I mean, the regression seems like evidence of something, for sure.
Right, and I think what matters here is that there's evidence of a pattern of regressions, right? Maybe in a case where there was no evidence of previous regressions, it wouldn't matter as much, but I think it's certainly evidence of unfitness when there's this ongoing pattern. We already have ample evidence that she regressed while in mother's care. So I think in those circumstances, it is pretty compelling evidence of unfitness.
All right, your time is well over, although, okay, thank you very much. Excellent argument, and we will hear finally from Attorney White.
Good afternoon, Your Honors. May it please the Court, my name is Jonathan White. I represent the minor children in this matter. Your Honor, a lot of the issues that I may have addressed have been discussed with my colleagues, but I do have some commentary about the situation. My concern here is that although Mother had repeated similar circumstances, the patterns of conduct, which may not have stood alone as being problematic, arrive as a problem, for me, particularly where it's laid at the feet of my client, the little boy. It is not only unfortunate, to me it represents the kind of failure that repeated parenting classes should have addressed and connect to the expert opinion that said further services would have been needed in order to continue. We've had 3 removals in this case. We've had a waiver of 72-hour rights. We had a waiver to allow the children to go into permanent custody. There were times when Mother could have brought this matter to trial and did not do so. She elected to follow through with services, but the services seem to have had no avail. Now, one could say that fighting with a stranger at the DSS office is, it's kind of cranky. Maybe we shouldn't have done it. But had that been on the street and had the police arrived, there would have been a removal. That it happened at the DCF office maybe was fortunate, but it put the children potentially at risk. Fighting with my younger child's daycare worker seemed to put the child at risk. Having a foolish argument, a setup where Mother brings food to a visit, which seems excellent, and then prompts an argument that if my children are eating, they must not be eating at the foster home. Doesn't seem sensible. It is concerning. She imposes her own ideas in a way that the children are damaged. Now, there are concerns, of course, in the way that the court may have elected to evaluate the expert opinion. One can say that there was effort to control the test. That control mechanism is internal to the evaluation of the test. The expert doesn't do that. It is assembling and reading the responses in a way that is in an effort to control it. It is more concerning to me that in the self-report, there was intentional, in my view, effort to not disclose the kind of abuse and neglect that might have shaped the kind of services the expert represented that were needed. Didn't happen. That self-report failed. Now, turbulent personality, it isn't in the DSM yet, maybe will be there, but it certainly seemed to fit the characterization of the mother. If I might address some questions, however, about the children's current needs, I see the panel has asked. My client, the young boy, has completed his ABA therapies. He is now mainstreamed at school. He has lost his IEP because he's made so many gains. However, he has an educational advocate because he has trouble with his autism interacting with the teacher in order to have his education advance. Monitoring of my younger child's cyst is ongoing, but not a problem for Children's Hospital. The foot problems have been addressed. So there are advances at the home.
Are the children together and at the same foster home? And
They are.
Does it remain a pre-adoptive resource?
It does. And you have asked my sister about other children in the home. Currently, there is a college student and a late high schooler who are the pre-adoptive family's children. If there are no other questions?
I see none. Thank you very much.
Thank you much.
Thank you, all three of you. These are our hardest cases, and so your assistance is very much appreciated. Thank you. The case is submitted.
I didn't think you used paper anymore.
I love it. I wish they would let me use paper. God.
I was actually thinking that I would do this. I'm a poor reader on the computer.
Yeah, I would love to have a nice appendix, some colored briefs. It'd be fabulous. Oh, do you have a pen in your thing?
Yeah.
Pen or no?
No.
Do you have a pen in your?
They're weird colors, but.
I just hate that, too. We have one more matter remaining. It is number 23-177. John Doe 527405 versus Sex Offender Registry Board. I will remind you, and I suppose us as well, that this is an impounded matter, and so pseudonyms should be used for the parties' names. And with that, we will hear first from Attorney Gautier.
Yes, Your Honor. Good morning, Your Honors. May it please the Court. My name is Attorney Edward Gauthier, and I appear today on behalf of the plaintiff appellant, John Doe. Mr. Doe was finally classified as a Level 3, or preliminary classified as a Level 3, finally classified as a Level 2, and that Level 2 was upheld by the Superior Court. We have appealed, making two arguments. One, the substantial evidence argument, and secondly, we take exception with the way the board applied 5 of its regulatory factors, 1 statutory high-risk factor, as well as 4 risk-elevating factors. And just to hone in on the argument, it essentially deals with how the hearing examiner treated the 2007 Rhode Island conviction for disorderly conduct, as well as the use of a police report and a conviction for indecent assault and battery on a person 14 or over to find that the Doe committed rape of a person involving a high degree of physical contact. So the 5 risk factors that we take exception with, of course, is the very important repetitive and compulsive behavior. And our position is that the Board should not have applied repetitive and compulsive behavior when we had a 2007 disorderly conduct for public masturbation, followed by a 2020 indecent
So
assault.
I read that and I thought, well, this is fascinating. And then I looked at the regulation. It says sexual misconduct. It does not say sexual offense. Now, it's true that the hearing examiner wrote a sentence which says the highest use of this or something, the strongest uses in cases where there has been a conviction of a sex offense and then subsequent misconduct. But then the analysis doesn't say I give it the highest, and even if it did, that initial sentence about what's the worst, I don't even know where that comes from. So what do you say to that?
Our position, Your Honor, is that it was a mistake for the hearing examiner to rely on that police report to determine that that was sexual misconduct sufficient to establish.
How can that be? We let the hearing examiner make findings by preponderance of the evidence about acquitted conduct sometimes, right?
We do, Your Honor. Our position, again, is that it was an error for the hearing examiner to do that. Moving to the actual meat of the index sex offense from 2020. This was an offense where my client at the age of 47 was charged with forcible rape of an adult woman, his 28-year-old girlfriend, and he was given a 6-month House of Corrections sentence for indecent assault and battery. Our position is that it was an error for the hearing examiner to use that police report to apply the risk-elevating factor level of physical contact. We believe it was a mistake for the hearing examiner to find that level of physical contact given the police report, and especially given the disposition. When a hearing examiner evaluates a index sex offense, the hearing examiner can consider everything, the police report, the trial record, the transcripts, and in this case, we have a finding that my client committed a forcible sexual assault, essentially a very violent sexual assault, but that doesn't jibe with the fact that he received a 6-month sentence to the House of Corrections.
So how much contact do you think there was?
I wasn't there, Your Honor. All we have is the police report and admission to an indecent touching with a 6-month sentence.
The only description of it anywhere that I have seen is that it was penile vaginal penetration.
That is, Your Honor. That
is the highest degree of contact, I think, or one of the highest degrees of contact possible.
Within normal sexual congress, that is, within the board's regulations, that's the highest level of physical contact. However, the only physical contact of a sexual nature alleged was the penile vaginal intercourse. There was also allegations of physical assault. There was kidnapping. There was alleged.
Sure, but does the hearing examiner rely on those aspects of it, or just for degree of contact?
The hearing examiner essentially gave credit to the entirety of the allegation that the victim made against Doe in that, while not weighing the fact that in spite of this extremely serious allegation of extremely physical, violent sexual misconduct, he wasn't indicted and he received a 6-month in the House of Corrections sentence. That does not...
But there are so many reasons that happens, including, understandably, a sexual assault victim's reluctance to testify. That we don't know what went into the decision to keep the case in the district court and have the result that it did. But aren't we allowed to consider, for purposes of the index offense, everything that happened leading up to it, including the allegation that he threw her over his shoulder, he repeatedly struck her in the back, he carried her to the bedroom, he pushed her onto the back, got on top with her, she stated she didn't want to engage in sex. He says you don't get to decide that stuff. I do. I mean, isn't that all something that the hearing examiner can consider?
That is everything, that is mostly everything that's contained within the police report that are the allegations that the victim made against the Doe. And I'm mindful, I am personally mindful of the Doe 10-800 that allows for hearsay, that it is
reliable hearsay.
Reliable hearsay. The question is, given the disposition, given what happened in court, how do we actually assess the reliability of this victim? All we have is a hearsay statement in a police report, and then we have what if this was the defendant murdered I saw the defendant murder 10
But
children.
she went to the hospital, she had a forensic examination, there was a DNA profile. That's corroborative evidence, no?
The fact that she went to the hospital, I would not say that's
Had
correct.
a rape kit exam, and they were able to have a vaginal swab that linked the DNA profile to your client.
I would agree that if this were a stranger rape, DNA evidence showing anyone's sperm inside of a victim would be fairly conclusive evidence of identity. However, we have to keep in mind that this was a boyfriend-girlfriend relationship.
Right, but you're saying that all you have is this unreliable hearsay in a police report, but you do have corroborative evidence, and he pled not just to the indecent A and B, didn't he plead to the kidnapping?
Yes.
I don't know that the sentence that he received and the reduced charge equates to a finding that the hearing examiner's findings were arbitrary and capricious in some way. I mean, they started out at a level 3, and he ended up classified as a level 2.
We are very mindful of that, Your Honor.
We don't have the plea colloquy, right?
We do not. That was not submitted by prior counsel or board counsel at the hearing or at the 30A stage. So we don't know anything about the travel of this case in the criminal case in the trial court. We have nothing. We essentially, in these cases, at least on appeal from my perspective, is we get the board administrative record. So we're not permitted to go beyond that. We have to argue solely within the four corners of the papers.
I'm curious if you could move on to your factor 33 and 34 argument, because I think the hearing examiner can say, I'm not going to give full mitigating weight when his current girlfriend or fiance, I'm not sure what she is, says, I don't think he committed a sexual assault. So and I think you don't disagree that they have the discretion to do that. So what is the hearing examiner to do? I mean, she did give it some weight, or he. What else should have happened?
So I will, and my client will concede that the testimony of his girlfriend at the evidentiary hearing was bad. It's not.
what?
It's not what any attorney would want to have for their
You saying
client.
it was bad?
It was bad. I have done.
I appreciate your candor.
I've done maybe 100 hearings, and I can say that other attorneys who do this, we prepare our witnesses to do exactly the opposite of what this witness did. It was bad. When we prepare witnesses, we say, this is not a forum to adjudicate guilt. You're guilty. Your loved one's guilty. Even if you don't think they're guilty, you do now. But I will concede that factor 33 and factor 34, which we argue, the problem with them, yes, we agree that some discounted weight can be taken away because she doesn't believe in his guilt. But I would point out that she's not ignorant of the fact that, number one, he took responsibility and he admitted to committing the offense. She was there for all of his court dates. In addition, it's not just her. He had letters of support from 9 different people. I don't know 9 people who would support me if I committed a sex offense.
I hope you do.
If I committed a sex offense, I can assure you I'd have none.
I thought, though, that what was interesting about the letters, and I don't know if this is a fair word, but it's the only one that's coming to my head right now. I felt that other than his dad's and the girlfriend, they were fairly generic. Like, he's a good guy in the neighborhood, is what I kind of read them to be. Let's assume that that's true. I don't know how that moves the needle one way or the other, frankly, on the level.
I can say that as cases go, having letters at least as good as the ones you are makes it a pretty good case. A lot of these cases, all we have is...
Well, but again, it was knocked down from a 3 to a 2. I mean, the real question here, right, is there a moderate
risk
of reoffense?
and degree of danger.
Yes, and degree of dangerousness, but given the crime, maybe that's not so hard to show, assuming that would be what happened again. The risk of reoffense... I mean, I don't know what to say about that. And of course, I'll ask Attorney Chennai, as I always do, how we're supposed to sort that out. I won't give him a hard time about it, though.
I would
maybe a
ask
little bit of a hard time.
I like Dave Chennai a lot. I'd ask Your Honor not to give him a hard time.
Well, it's not his fault.
When is your client up for a new hearing?
He gets a new hearing 3 years after the final classification, so his final hearing was in 2021. The final agency decision issued in 2021. So that's one thing about these
This year.
cases.
Yeah,
that you
it's
see.
weird.
We see these cases cycle very predictably from hearing to 30A to appeal to FAR denial at the SJC. And the good news is we can always tell our clients after the SJC, you got 3 weeks until your next hearing. Because just the way it cycles through, we generally have anywhere from immediate to a hearing within a year. And I believe that in this case, my client, having kept his nose clean and not picking up any new offenses, he will be able to petition the board for petitioner-initiated lower reclassification by the end of this year. So whether he wins or loses, the benefit of victory, of course, in the court is good evidence. Sometimes we get evidentiary rulings, but the main benefit when we have a person who does qualify for reclassification is they're taken off the internet. They're essentially unclassified. So in this case, I will say to the court that my client will have a hearing, probably in 2024, win or lose. The benefit he may get is an evidentiary ruling in his favor, and the benefit he may get would be to be taken off of the internet. Finally, I would say that, as this court knows, a decision has to issue based on the evidence closest to the hearing. Evidence closest to the hearing is stronger than evidence the week before, and as evidence gets staler and staler, it becomes less and less valuable. And at the time of the hearing, although he did commit a second offense OUI in 2020, he did the 14-day program, and although he did have trouble in 2020, at the time of the hearing, by all accounts, he was doing well. Although his girlfriend does not believe he's guilty, even though he admitted that he's guilty, he was 100% in compliance with his probation. And it's not just probation of don't commit any crimes, it's probation of GPS, sex offender registration, counseling, probation. So for whatever it's worth, at the day of the hearing, it appears as if he was doing a little better than 2020, which seems to be perhaps the lowest point of his life. If there are no further questions from the panel, Doe and I would rest on our brief.
I see none. Thank you very much. Excellent argument. And we will hear now from Attorney Chennai.
If it pleases the court, David Chennai for the board. Again, I think Attorney Gauthier's, it's a mutual friendship we have, and we like each other a lot, but I think in this case, I think the level 2 was very fair. Considering that he committed the sex offense within 2 years of the classification hearing. Justice Rubin, I think we discussed this in the past, the fact that I don't always agree with the hearing examiner's decision. I think this individual could have been easily a 3, but the hearing examiner did take into mitigating evidence the support network that he had, albeit gave it moderate weight, but I think that's really what tipped the scale down to a level 2. And I think I've addressed the issues in this case very thoroughly in my brief. Unless there's specific questions, I'd be more than happy to rest on my brief.
There are have the new guidelines come out? Are they still being worked on?
Right now, I believe they're at EOPS waiting for approval. They've been there for a little bit of time now, so I'm not sure when the end date of them coming out of EOPS.
They still don't address my actual concern, which is how high a risk counts as low, moderate, and whatever the highest one is. There's no metrics, there's no numbers. We're not told which high-risk factors mean more or less. Nothing, right? Because the analysis here, I'm sure we've affirmed analyses like this, but to say, having weighed all these factors, I conclude that by clear and convincing evidence that this is a moderate risk of reoffense would be a lot easier to swallow if all the factors indicated an 8.21% risk rather than a 1.3 risk, you know?
No, I have a feeling you're going to be disappointed in that area. I think they're basically taking the factors, adding new factors, and maybe eliminating factors based on recent research.
Yeah.
But again, I think even in the research, other than the desistance research, what they generally are looking at is the same thing the board is looking at, is different factors that indicate elevated risk or lower risk. And I think that sadly is the paradigm that's being used, not only by the board, but most experts. Even Hansen kind of talks statistically, but still goes to what factors may improve or increase or decrease. In fact, even in the desistance studies, he still looks at the static 99R scores as the beginning of when each individual sex offender's desistance rate will either increase or decrease, such as he says in the 2018 study, if an individual has a static 99R score of the highest level, his desistance and age rate is going to exceed the 20-year mark, whereas someone's a low, that the desistance rate actually might still be somewhere in the 10-year range. And again, the desistance rate isn't zero, it's based on a percentage, and even Hansen will admit there's outliers to that number. So I think that, again, it's going to be the same type of paradigm, just more refined on the updated research.
Okay. I see no questions. Thank you very much, both.
Thank you. And it's always a pleasure to be here.
It's always a pleasure to see both of you. The case is submitted.
Thank you.